lordship has reserved the order. To be mentioned has been from the last week. Directed me.
Pardon to mention, my lord. This is the release of vehicle, my lord. Before this Hon'Ble Court file the present petitioner.
Give the memo.
Assignment
has changed. I'll have to see.
205 rejected.
It's all right. Give the memo. We'll take it.
dispute between the husband and wife, my lord.
Time, to settle things because now assignment is changed.
The husband is now
You
available.
give the memo. I'll see. I'll not specialize. I'll not prioritize anything.
My lords, I want to mention item number 21, my lords. I want to withdraw myself, my lords. I am from the petitioner side, my lords.
You want to withdraw 21?
Yes, my lords. Item number 21, my
Do
lords.
you have any junior with you who can give a memo?
Yes, my lords. The petitioner is available there in the court, my lords.
Wait. Memo, you have to give
He's
memo.
outside, my lords. He's outside. I have already given the memo yesterday, my lords.
Okay. Memo 21, withdraw.
21, item number 21.
Yes.
I may be pardon, Lordship. I'm mentioning, Lordship, is 2018 matter CMP. Whole difficulty is there is no interim order. It was hard before.
Give the memo, give at least 2-3 days you leave. Let me understand what is the assignment, how I'll adjust. Yes.
Out of list, my lord.
Yes.
My lord, one CRLMC number 24924. It was listed previous week, but court was not functioning, so it was adjourned
Memo, we are adjusting all the matters which I could not see.
adjourned to May. So
Then you have to move application. I can't help it. For
I may be
preponement.
pardoned to mention, your lordship. I
Anyway,
may be pardoned to mention, your lordship. Your lordship,
Yes.
item 95. Your lordship,
Yes.
item 95 has been fixed for today. So kindly be taken up today, seeking for no adjournment, your lordship.
Why are you so apprehensive that I'll not take it up?
Your lordship, we are prepared. Like my honored senior counsel, Mr. Palit, will be appearing for this matter, your lordship, and will hardly take for 10 to 15 minutes. And your lordship, this matter is pending since 2009, your lordship.
It's all right. You prepare your written note and
Yes,
come
your
at
lordship. Yes, your lordship.
about 3
Yes, your
o'clock.
lordship.
Not
Obliged,
before
obliged,
that. Not before that. Okay.
obliged, your lordship.
Your lordships, I am in VC, your lordships.
Yes.
Your lordships, I am in VC.
Yes, Mr. Naik, you are mentioning.
Yes, your lordships. Your lordships, on 6th, your lordships are directed 2 matters to be listed. 2 matters pertaining to the same cause of action. The accused had filed quashing. I had filed the application for voice sample. Lordships, you remember that matter when Mr. Tanvir used to come?
Yes.
That matter, your lordships had specifically directed that no adjournment will be given. Your lordships, his application, which was filed in 2025, is listed after 2 weeks. My
Sixth,
application
I was
is-
not holding court. That's the problem.
Lordship, let both the matters be tagged together because your lordships are told that let both the matters come on the same day.
You give both the numbers. I'll tag it and list it. Okay.
Yes, your lordship.
Give the
please.
numbers. Give the numbers.
Item number 1, my lord.
Your junior, tell the junior to give the numbers so that I'll tag it and
Yes, your lordship.
Item number 1, my lord. I pray for an adjournment, my lord.
I'll just call. Please. Yes.
1 to 3.
Item 1, my lord.
My case has been initiated and NBW was issued on 9/5/2024.
First of all, you wear a band. Are you appearing in person?
No, I was in.
No, you can't appear like that. You please wear the band and appear. Okay. Next.
Item 1, my lord. Item I pray for an adjournment, my lord.
Urgent. Okay. With request urgent. Yes.
Item 4 to 13.
Item 10, praying for adjournment.
Yes. On request.
Item 11, my lords. Item 11, my lords. May I
Yes.
prefer short adjournment, my lords? I have filed a written note, my
11
lords.
urgent. Yes.
Item 7, my lord. Pray for adjournment.
7.
7.
7 also urgent. Okay. Urgent.
Adjournment.
Yes.
Item 14 to 27.
Item 20 on request.
Item 20 and 27, my lord.
20 and 27. Urgent.
Can you take? My
Okay. 20, 27 on request of petition. Yes.
28 to 42.
Yes.
43 to 54.
lord, 43, my lord. Can you take one?
Okay. 43 on request of petition. Yes.
Public.
55 to 63. 64 to 70. 71 to 76.
76, my lord. Adjournment.
76. Okay. 76.
77 to 83. 84 to 91. 92 to 98.
My lord,
Lordship, may 95 communication gap, the instruction was to oppose adjournment, not to pray for expediting hearing.
Oh, no, you get ready. You are there.
No, I'm more or less. I'm
I'll
ready.
take it up at 3:30.
No, at your Lordship's convenience, the communication gap, at the instruction was to oppose adjournment, not to postpone hearing. Yes,
My lord, item number 96.
Yes,
Item 96, I pray for on adjournment.
adjournment 90.
My lord, one small pair before Lordship. Lordship, let the paper book to be ready in the file.
We'll see. We'll see. You have to take the pen drive and get it done. We'll see.
My lord, one criminal
Yes.
case, my lord. SLP has been
Which
disposed
case?
of by Honorable Supreme Court, my lord.
Which case?
In this case, my lord. Out of list, my lord. Petitioner has deposited 30 lakhs before the company, my lord. Thereafter, my lord, FIR was registered as per direction of this Honorable Court, my lord. Thereafter, the opposite party preferred SLP, my lord. Same has been dismissed. Lordship, kindly taken up, my lord. Petitioner money has been held up, my lord, day after tomorrow.
Not day after tomorrow. I'll adjust it, but prioritize for this. Okay. Yes. I'll just see. Okay.
I have understood.
Yes. Yes.
99 to 101.
Okay. Yes. Let us start.
Item 2.
May it please, Your Lordship.
Yes.
Item 2, my lord. Initially, Your Lordship, a case registered against the teacher by the parent of one of the victims. 8 victims are there, my lord, in this matter. Lordship, may kindly turn to page number.
You are the teacher.
I am the teacher, Your Lord.
What are the allegations?
Allegation for molestation only, my lord. Only. Molestation 354, 506 and section 12 of the POCSO.
8
There are-
girls, Prince. 8 girls.
What do you want now? Watching?
Here, Your Lordship, I am before this Honorable Court for 2 IA I have filed, my lord. One is for adding the opposite parties, new opposite parties, my lord. Because 8 persons are there, the parents must be party.
No, in the main petition, what are you seeking?
I'm seeking for quashing of the proceeding, Your Lordship.
On what ground?
On the ground, my lord, there is a plea of alibi. And the parents also said, my lord, I am not involved at that time. And the
All these things are,
Your Lordship,
it has to be decided in the
office order itself stated, my lord, the block education officer suspend me for the different issue, different time. And I am fixed at the station for the BEO. At that time, I am not there. This is the office order also there.
So the plea of alibi has to be established on trial only.
Your Lordship, plea of alibi will take at any time, Your Lordship. There is a
You can take, but it has to be established.
Establish, Your Lordship. That is correct, my lord.
You establish it.
My lord. But my lord.
Where is the question of interference in 354 by a teacher against the students?
My lord, there is no material, my lord. The parent itself mentioned that we are not there.
Now at what stage? Cognizance?
No. I am challenging the cognizance and proceeding. I am also filing a IA for amending the prayer, Your Lordship. I am, after getting consent from previous counsel, I am appearing in this
Okay,
matter.
simply you do the application. I'll allow the application. I'll hear it. Huh?
Okay, IA application may kindly.
Which application?
IA number flag B and flag C.
What is the 698? What is this flag B?
Flag B is for adding new opposite parties.
Allowed for the reason stated in the application. The same is allowed. The petitioner is to file consolidated.
Already filed, my lord. Flag X is the consolidated.
Okay. Flag X consolidated has already been filed.
And flag C is the amendment of prayer, Your Lordship.
For the reason stated in the application, the application is allowed. Petitioner is allowed to amend the prayer. And
consolidated prayer also filed, Your Lordship.
Already filed.
Filed, Your Lordship.
Already filed. Okay.
A short date may kindly be given.
We'll give it. Yes. Next. Okay. Yes, sir.
May I please, Your Lord?
Yes.
My lord, the petitioner here challenges FIR on Ranexer 1, which was registered under section 294, 506, 500 and 34 of IPC. My lord, on the ground that in the face of FIR, it is ascertained that no offense has been committed. And the
You have filed two FIR. What is that?
2 FIR from same transaction, Your Lordship. What happened in this case?
But investigation is going on.
Yes, Lordship.
Yes.
Malad, your lordship called for CD.
Why investigation is going on? Why interference?
Because no ingredients of the offences are made out, my lord.
They are searching it out, whether ingredient is there or not.
My lord, what
On the basis of FIR, how can I reach at the conclusion? Let them investigate.
290, I may permit it, my lord. 294 offence has been alleged. The ingredients of section 294 is that it has to be committed in a public place.
It may not be there. After investigation, it may come. How do you know? How do you know?
My lord,
If it will not come, they may file a closure report against you. Today, how can you preempt everything?
what happened? Why I am apprehending that there will no final report in this case because police is involved in this case, my lord.
I don't know. I can't presume things like that.
On the instigation of police.
Are you on bail?
Yes,
Tell
lord.
me the real.
Yes, lord. I am on bail.
You are on bail.
Yes, lord.
Let it be investigated.
My lord,
And I can only tell that whatever you want to
your
tell,
lordship may peruse the allegation of the FIR for a moment, your
Then
lordship.
in the how
Because
can,
what
investigation is going on?
Yes,
How
sir.
can you decide the case like this?
Because
How can I preempt an investigation?
for a moment, your lordship may peruse the
Show me.
FIR.
Okay, you want to
What allegation is made, my lord? Under annexure 1 at page 21, your lordship.
Yes, I am there.
21. Here, your lordship, I want to place one thing. Your lordship may see the signature of the informant. First, Balabhadra Malik, but he has not cited as informant in the formal FIR. Your lordship may peruse page 2019. Satyavadi Behera is the informant, column number 6, your lord.
All you so tell us.
What happened? All the journalists have lodged FIR against another journalist, my lord. And your lordship may peruse what offence alleged.
I'll simply issue notice.
I'll
simply
yes,
issue
lord.
notice. Yes, issue notice.
Uh,
I'll just issue notice. That's all.
That 4 also same, my lord. In another FIR, which is
That journalists and everybody is involved. Police, journalists, and all these things are, cooked up stories.
This is the happening, my lord.
I just issue notice, just take it as what to tell me. Yes.
Item 5. Like, pardon me, item 2, I will take notice to the opposite parties.
Issue notice to the newly added, respondent.
Okay. Grateful, your lordship.
5.
Petition was requested for an
5 has been sent to mediation, matters settled.
Okay, adjournment request. Okay. Yes, 6. Settled.
Matter was sent to mediation. Mediation has been successful.
Where is the mediation report?
16/12/2024.
Informant, my lord. My lord, my senior is today out of station.
Mediation here successful.
Yes, my lord. Already successful.
On that time, I'll dispose it up. That's all.
Payment made, my lord, terms and settlement there. Payment has been made.
That
already made, my lord. Can take up next week any day.
No. Don't waste time. Mediation both of the parties are bound and I'll dispose it up. If any problem is there, you move application. If he has already paid, have you paid?
Yes. My mediation.
Why unnecessary pending all these things? Right.
As for my instruction of my law and senior, so can take next week any day, my lord.
1 minute. The persons to the this matter was when it was sent to mediation.
Well, it's a mediation.
Yes. By the order dated 16/8/2000, when the matter was taken up for hearing on 16/8/2024, the following order was passed. 16 order. Pursuant thereto, the matter was sent to High Court Mediation Center. The mediation came out to be successful. The High Court Mediation Center, by its letter dated 25/9/2024, has placed on record the mediation report dated 19/9/2024. In the mediation report, the terms of the settlement has been enumerated.
The final report would be on 16th December.
16 December 2024 is the final date when terms and everything was signed.
16 December. Where is that? No. The mediation report and in both the sides and peruse the generated various option of settlement of parties. Both the parties have agreed to settle the matter and to proceed further. And the petitioner agreed to pay 10 lakh rupees.
10 lakhs.
10 lakh rupees to the informant, so and so. And also, informant agreed on that. The petitioner undertakes that he will submit a demand draft of 5 lakhs on so and so in favor of informant, and rest of the amount 5 lakhs will be paid. 2 equal installment, 2.5 you have
That has been paid.
That also paid.
16 December, everything writes down and dispose of
Where
mediation.
is that 16 December wala?
16 December 2024.
Do you have that?
Well, it's
16 December wala, see, देखो.
the last report.
देखो 16 December wala.
Which I have it, but
Yeah.
the loose copies are there.
Give me. The parties have agreed, the petitioner has agreed to pay total amount of 10 lakhs to the informant. Out of that, 5 lakhs, 5 lakh draft of demand draft of 5 lakh rupees was paid there, and the remaining 5 lakh was to be paid on 2 equal installment. Subsequent thereto, the petitioner has also made good the payments of the 2 installments. Finally, on 16/12/2024, the mediator has concluded the mediation proceeding inter alia recording agenda. 16/12 inter alia recording. The matter is disposed of in terms of the mediation report. The mediation, the terms of the settlement as enumerated in the report dated 16/12, so it's formed part of the present order. Both the parties are both the parties are bound to comply their part of the obligation in view of the aforementioned the petition.
Both of them have complied already.
Yes.
Only the monetary part was there.
Yes, I've written that.
And so far as that FIR is concerned, well, it's
So accordingly, the FIR number so is quashed. Yes.
Obliged.
While the petitioner is quashed. Yes. Next.
Obliged.
Item 8.
8. Yes, sir.
Sir, for Central Office Order, my friend has already filed that affidavit to Lord.
Have you filed? Have you seen it?
I have. In fact, I got it yesterday.
Okay.
I want to go through.
You file a rejoinder if you want.
No,
Okay.
rejoinder is not required. You lost me fix it on Wednesday. I can
Not
dispose-
Wednesday, I'll give it in. Tell you. I know that.
Then next Friday, next Wednesday.
He's not well, let us.
No, I'm not. Next
Right on.
Wednesday.
Pursuant to the order dated 5/3/2025, the Mr. Maharana, learned counsel for the Vigilance, has filed the counter affidavit, and a copy of which has already been supplied to Mr. Samantrai. Leaves the matter for
19th.
this order.
One.
Let me, because the assignment has changed, I'll have to adjust things. Because there are many matters has come. I give me 2 days so that I can adjust the list how to go about it.
Why I'm similar, Lordship can only dispose of in terms of I was going
And if
to-
you want a dismissal, I'll do it right now.
Not this.
Why to wait till 19th?
The 19th, in terms
Let me see, I'll try.
And 9.
Yes.
The matter has already been settled. Last week, also what the charge sheet. In the meanwhile, the investigation has already completed on 25/12/2024, and the
What are the
investigation is
offences?
submitted charge sheet on
294, 506.
Yes.
Where are the parties?
Parties,
Settlement means parties will be there.
Lordship.
At least, learned counsel for the petitioner
Day after
and
tomorrow.
the
Day-
counsels appearing for
day
both
after
the parties conjointly submits that the parties have settled their dispute. After investigation, charge sheet has been filed. In the present case on
25/12/2024.
for alleged commission of offences.
294, 506.
294 and 506 IPC. Leaves the matter for dispute. Yes. Bring them. Next.
Day after tomorrow, Lordship, day after.
You don't decide the day.
No, I am beg pardon, Lordship.
Are they VIPs?
No, my
If
lord.
it's settled, then they should have come. I can't upset the listing process. You have wasted one hearing. You should have brought them immediately.
Both are.
I can't adjust my this thing depending upon the accused's convenience. Court's convenience is also important.
No.
Then accused want that he'll come on 19th, so therefore the court has to wait for it.
Both are government amendments.
Don't make those kind of maybe you should have brought them here. Accused convenience is not very important for the court. You settle the dispute, then you should come. First of all, you wasted today's hearing. And again, 19th, I'll have to wait. Yes, please sit according to our board. Yes.
Item 12.
Yes. 12. What is this? 12.
There's a VC, my lord. Parties are in VC.
Well, already in VC.
Huh?
Parties are in VC.
What are the offenses?
Well, yes.
323.
Yes.
294,
Well, 323. SC Act is there, my lord.
What are the allegations?
In this case, 341, 294.
No, tell me the allegations.
My lord, misbehave with the reserved class. And your lordship will kindly turn to page 42. There the complainant has already filed an affidavit that he doesn't want to proceed in the matter.
I understand what are the allegations I'm asking.
Yes. My lord, allegation is
it serious allegation or what?
No, my lord, there is no serious allegation.
Page 9.
Only after the words Soda contra.
Longer paisa nadaru.
There was a dispute regarding cultivation. He uttered the caste name.
Okay. They are villagers.
Villagers.
Same village.
Well, they are in VC, if you lordship.
Where are they?
VC ta open code. So, man, option this is Baleswar virtual court.
Himanshu, Amruta, Subrata.
Malad, there are two matters before you. Malad, they are in VC, Malad.
Nagendra Jana. Ki Nagendra? Apan na kono?
Nagendra Jana.
Nagendra Jana. Accused. Where is accused?
Aloko accused manako kon to asbe.
This is the Aadhaar card of the informant.
No, where are the other persons accused? Himanshu, Amruta, Pradhan, and all of them. Are they there?
Yes, Malad. All are there.
Right on. At the instance of opposite party number 2, FIR number also came to be registered against the petitioner. The allegation against the petitioner and so on. So, charge sheet filed?
Yes, Malad. Charge sheet
and
filed.
After investigation, charge sheet in the present case has already been filed on
Malad, charge sheet has been filed on
2017. What is the stage now?
Malad, now the trial was going on. Malad, there are two matters. 482 is there for quashing. Revision is against the refusal to discharge them. The revision is also connected. Now evidence has not started.
Due to stay, my lord, in second case.
Okay.
Matter is not proceeding.
Okay. Due to stay. Okay. First matter. Charge sheet is filed so and so for alleged commission of offence under section 341, 294, 50634. Reduce section 31X of SC/ST bracket POA Act. The petitioner moved an application. Petitioner moved an application seeking a discharge. And the said application was turned down by the trial court by its order dated. Order dated 18/1/2020. The said order was assailed by the petitioners by filing a criminal division number 4. Second division. In the said criminal division, this court, the coordinated bench of this court, by the order dated 30/6/2022, stayed the trial court proceeding. Therefore, even after the charge sheet is filed and the application for discharge moved by the petitioner has been rejected, trial has not yet been proceeded. Next, when the matter stood thus, parties have entered into a settlement. The petitioners have filed an affidavit dated
My lord,
opposite
the-
party number 2 has
yes.
filed an affidavit before this court dated
19 to 24.
19 to 2024 inter alia stating as under para 1, 2 and 3. Para 1, 2 and 3.
I'm also appearing
The
opposite.
parties, all the petitioners and the opposite party are present in the court through video conferencing mode and being represented by their respective counsel and identified by them. They've also filed the self-registered copies of their Aadhaar card to establish their identity.
Your lordship may direct them to give a photocopy with the attested in
Self-attested copy.
there, madam.
Yes. On query from the court, the opposite party number 2 submits states that the petitioners are their co-villagers due to misunderstanding and the FIR has been raised. However, to maintain peace and tranquility in the locality, he has entered into a settlement on the intervention of the village gentry and well-wisher. Therefore, he is not willing to prosecute the petitioner anymore. Mr. Fonso appears for the state and submits that since the allegations are minor in nature, the parties have settled that issue. All of them are present in the court. Opposite party number 2 has already filed an affidavit before this court. Therefore, this court may give indulgence to the petitioner as there is no legal impediment. Regarding that, the aforementioned, Jansing and all, was yes.
I had the occasion to see my lord's judgment in that POXO matter. My lord, I don't think so that nothing remains in my case to be added more.
But I have taken care of
I'm
the
grateful that your lordship has taken all the
all these
factors
things.
into.
Therefore,
Even the Supreme Court, how the Supreme Court judgment is to be accepted.
So I have not distinguished it.
No.
On that basis, we can.
Yes, your lordship has kept that, and that said that what is private and what is against public.
Yes. Yes.
Second matter accordingly disposed of.
Both the matters disposed.
Obliged.
Your lordship may direct the virtual court staff to accept that
Yes.
because that will be part of your lordship's record.
Yes. Next.
Grateful.
Yes.
Item 13 I may be permitted from Vessi Millards. My lords, am I audible, my lords? I am 13, I am from VC, my lords.
Yes.
Yes, my lords. My lords, order taking cognizance on the basis of a protest petition is under challenge, my lords. May I take my lords to the annexers, my lords. Annexer 1 is the FIR, which was lodged against the petitioner for offence under section 341, 323, 354B, 376, 109.
Yes. Forget the sections.
My lords.
Closure report was filed.
May your lordship, by the annexer 2, my lords, investigation
closure
was
report is
completed and it was submitted as it was returned as FR false with the findings. Your lordship, kindly see paragraph 4 of my petition, my lords. The findings of the investigation report, my lords, one is no such incident had taken place. Second is the OP number of victim in order to avoid a repayment of the hand loan taken from the petitioner has filed the criminal case in an exaggerated manner. Number 3 finding, my lords, the OP number 2 has filed a criminal case with an imaginary story which seems to be false and fabricated. Point number 4, my lords, as per the CDR of the victim bearing SIM number so and so.
See, I'll tell you it appears that for the recovery of the amount he has done it.
Yes,
but
my lords.
it is not a case where cognizance could be quashed because in protest petition he has made specific allegation.
Yes.
And in 202 also he makes that statement. That's the problem with you.
Millards, but here scientific evidence shows, point number 4, Millards.
I'll just issue notice because it's a monetary matter. Why don't you pay 2 lakh rupees?
Yeah, not I am to pay, Millards. It is the victim to other side to pay me. It is a case otherwise, Millards. That I have given him her money in order to avoid the
whatever, but it's a monetary dispute. Better you settle.
Yes, Millards. Notice may go, Millards.
Yes.
Next. Requisites, Millards.
Yes, requisite. Yes, next.
Requisites within 3 days.
Yes, within 2 days. Yes. Yes.
May it please your lordship.
Yes, sir.
The alleged occurrence took place in Barampur
Hmm.
and 1 CC case has been filed in Attagod and cognizance has been taken. That is under challenge.
Yes. Yes.
Page at page 12 is the order taking cognizance and the complaint petition relevant portion at page 14. May I place it?
Yes.
ଏହାର କିଛି ଦିନ ପରେ ଆମ ସ୍ୱାମୀ ଆମକୁ ଫୋନରେ କେସ୍ ହରାଇବା ପାଇଁ ଅନୁରୋଧ କଲେ ଏବଂ ବ୍ରହ୍ମପୁରକୁ ଆସିବା ପାଇଁ ଅନୁରୋଧ କଲେ। ଆମେ ବିଶ୍ୱାସରେ ସେଠାକୁ ଗଲୁ। ଗଲାରୁ ମୋ ସ୍ୱାମୀ ଏବଂ ତାଙ୍କର ସାଙ୍ଗ ଦୁର୍ଗା ନାୟକ ମୋତେ ଏକ ଅଜଣା ସ୍ଥାନକୁ ନେଇଗଲେ। ସେଠାରେ ମୋତେ ଜୋର ଜବ
You have been absconding.
I'm coming. My lord, kindly turn to page 46.
46. Yes.
The annexure.
Deposition.
That is the deposition. What he has stated specifically in para 2.
Yes.
He has stated who has taken part in the assault.
Arvind and Govinda.
My lord. Thereafter, my lord, kindly turn to page 15, the judgment.
Yes.
Thank you.
Yes.
Page, running page 17.
Yes.
In consideration of the judgment, in consideration of the medical opinion about the injury such and such, this is a MKCG Barampur. After being referred, therefore, about 10 to 15 days after the alleged occurrence, the false implication of the accused person in the alleged occurrence. So they have been acquitted. Hello. There are next page, the two accused
I
persons.
understand it, but you have been absconding.
My lord, I may place thereafter. Thereafter, other two accused persons face trial, and that is judgment dated 10/3/9.
I know this is the annexure 3 and annexure 4.
No, annexure 4 is there be annexure 3. The two accused persons, in spite of this deposition, they have been convicted. Thereafter, the judgment, kindly see. The appellate court judgment, that is in page 34.
Yes.
Just a moment.
34, appellate court.
Page 44, may kindly see last para. In
Yes.
appeal.
Yes.
We are losing faith of the. My lord.
Yes, I am there.
My lord, kindly see. Yeah, I do not want to place that.
Yes.
Thereafter, page 45.
Yes. It is expected that the
Well,
learned assistant
that maybe-
would improve his quality of judgment and appreciation of evidence.
Thereafter, they have been acquitted. Other two persons. Present two.
The net result is all the three accused persons have been acquitted. Net result is that.
Yes.
And you have been absconding.
No, he has
That's the
no,
net result.
he has no knowledge at all that he is.
Knowledge, you indulge in 307, you don't have knowledge.
No, he was outside.
And
this.
In view of all these things, what you surrender, I will direct the trial court to conclude the trial within 3 months.
No, he has already surrendered. He is on bail, charge not yet framed, my lord.
So I'll in view of that, I'll direct the trial court to conclude the trial expeditiously. Yeah, already you are on bail.
Yes, sir.
You will be acquitted.
That
obviously you will be.
But a trial will be there.
Yes.
Case has not yet been, my lord, charge not yet been framed.
Yes.
I have seen.
Total how many accused?
6 accused.
6 accused.
4 have already been acquitted.
Right. Petitioner petitioner is seeking quashing of the entire criminal prosecution initiated against him in connection with the Kavisharjanagar PS case number 112 of 1997, corresponding to GR case number 2001/1997 capital B.
Ar
pen-
B ହେଇଥିବ
pending in the court of
ଆର B ହେଇଥିବ
huh?
split up case ତ GR ଟା B ହେଇଥିବ
B
B ହେଇଥିବ
pending in the court of JMFC.
ନାଇଁ additional session judge
You have
କୋଦଳ
written in the prayer. Okay,
ଲେଖିଥିଲି
additional session judge Kavishuri.
କୋଦଳ
Kavishuri, na. Counsel for the petitioner has submitted that there are 6 accused persons who have been implicated in the present case. Out of 6, 2 accused persons initially faced 2 accused persons, namely Aurobindo Behra and Govinda Behra, faced the trial, being trial sessions case number 38 of 2000. By the judgment dated 31/3/2005, the learned assistant sessions judge Chhatarpur has recorded an acquittal in their favor, acquitted in the favor, despite the fact that the informant has specifically implicated them in their statement.
Very good.
The trial court, while acquitting them, has recorded age under. Page 17, para 5. Page 17, para 5. Para 5. Insofar as the other 2 accused persons, namely Swarajya Kumar Das and Balakrishna Naik, are concerned, they also face the trial in sessions trial case number 35 of 2003. Learned assistant sessions Jagat Singhpur, Chhatarpur, while its judgment dated 10/3/2009 has convicted the 2 accused persons, despite the fact that there was not an iota of evidence against them. These 2 accused persons have taken up the matter to the appellate court by filing criminal appeal number 30 of 2009. The learned sessions judge Parampur, by its judgment dated 4/12/2009, has reversed the judgment of conviction and sentence passed by the learned assistant session judge and has recorded that the assistant session judge has completely gone wrong by convicting the accused persons without there being any evidence. And the Sessions Court has also recorded dissatisfaction over the judgment rendered by the Assistant Sessions Judge Chhatarpur. Be that as it may, the net result for both the proceedings is that out of 6 accused persons, 4 of them have already been acquitted. The petitioners, both the petitioners, the present petitioner was shown as an absconder. Subsequently, he surrendered before the court and has been admitted to bail. Charge in the present case has not yet been framed. At this stage, the petitioner has approached this court seeking quashing of the entire criminal prosecution initiated against him on the basis of the finding recorded by the two courts as mentioned above. It is a well-settled principle of law that the evidence collected, evidence adduced by the prosecution is face trial qua the accused persons. The evidence which has come on record insofar as the accused who face the trial cannot be read into insofar as the present petitioner is concerned. The offences are serious in nature. Therefore, I am not inclined to entertain this petition. However, regard being head to the peculiar facts of the present case and the fact that the incident had taken place in the year 1997, I am of the considered view that the trial court should do well to see that the trial is concluded as expeditiously as possible, preferably within a period of 4 months.
Pending the court of additional session judge.
Pending court of additional. Yes. Next. देखिए लिखो 4
Last part.
Yes. 17. Yes, sir.
I was on behalf of Mr. Corona kindly personal difficulty not attend court today.
Okay, adjourn.
Kindly matter taken next week.
Adjourn.
Mayor, please.
I'm giving this up.
My lord.
Yes.
Offenses are under section 323, 325, 427, 370.
Yes, tell me what do you
My
want?
lord, the matter has been settled between both the parties, and my lord, both the parties are advocates. Allegation against the petitioners is that he slapped the informant due to what actions between both the parties. The matter has become settled between the parties. Informant is also present.
Where is the accused?
My lord, informant.
Where is the accused? You Nirmalendu Mishra.
No, my lord, he is the informant.
Prakash Chandra Mishra. Who is Nirmalendu?
The accused person.
I know, I understand. Where is he?
He is also present outside the court.
He needs an invitation from this
No,
court.
my lord, no, my lord.
Let him come.
My lord, kindly take it.
He is a lawyer. He doesn't have any problem entering in the court.
No, my lord, no, my lord.
He should have been here.
Kindly taken this matter after lunch, my lord.
Yes, sir.
Right.
What are the allegations?
Allegation?
Yes, Mr. Mishra. What was the allegation? What has he done?
When the Supreme Court was giving direction to close the strike and to arrest the accused in the latest long-term strike.
But can I do this? Because I was the lawyer there. In that matter.
Suddenly, see, I didn't understand.
Due to some misunderstanding, the matter has been compromised.
Settle the lawyers unnecessarily.
Annexure 3, page 18 is.
Forget about it. Forget about it. Bring them at 12 o'clock.
Yes, madam.
12 o'clock. I'll do it. Yes, 12 o'clock. Yes.
19.
Case is arrangement of matrimonial dispute, my lord. It's from one is the my lord.
498A.
Yes, my lord.
Okay, issue notice.
70 years and
Okay.
it's not 2.
Okay, issue notice.
76 years and
Yes, I'm issuing notice and move application for adjournment. Yes. Application for adjournment for trial court issue notice. Yes.
22.
Wait, please, your lordships. The petitioner, my lords, is challenging the initiation of FIR as well as the entire process. Here, my lords, the FIR initially was lodged under section 498A. But later on, the charge sheet has been filed under 493, 470, 34 IPC, SAST Act.
I issue notice. Same. Let us issue notice.
Lordships.
Yes, matrimonial dispute
It is-
primarily.
Lordship, it is not.
493.
matrimonial dispute.
It is not a matrimonial dispute per se, lordships. Fact is that she eloped with one person. No, one person.
First one.
First one. She eloped with one person, fell in love with another person. So she ditched the first one.
That's the more of a reason that they should settle.
Lordship. So he
She should take a decision with whom she wants to
She
settle.
wants to stay and
That's
pursue
all.
litigation.
That's all. That is what we will find out.
Issue notice.
I issue notice. Issue notice. And move application.
Lordships.
Move application for adjournment. I'll stay it. Rather, I'll stay it. Because I tell you, if anything goes on, then it will be precipitated.
Lordships.
And she can't take decision of where to go.
My lords may be pleased to stay it.
Take over. Yes. Interim.
Oblige, my lords.
These are the matters, if you it is precipitate, the chance of settlement is very blink. So it's better that stay, whatever has happened, it's all right. Let them settle themselves. That's
Oblige, my lords.
Yes.
May I please, my lord. My lord, challenging the automated annexure 4, my lord, that is page 11-11-24. The applicant filed with the petitioner to call for the records from the courts below was refused. The kind turn to the annexure 3, my lord. Petition as page 33, annexure 3, my lord.
33?
33, my lord, page annexure 3, my lord.
Yes.
Once the prayer question, my lord, that 2 records was called for from my lord JMFC Sonora and from my lord Additional Session Judge Padmampur.
On your defense.
On defense, my lord.
Yes.
And it was refused on the ground that.
Why are you calling?
Because, my lord, in this case, the father of the victim was an accused, and the petitioner was the IU in this case, my lord. Petitioner was implicated in the case of rape.
32, my lord. With the statement of the PW1, who is the informant, lordship. Cross-examination place 33, my lord.
Yes.
Said that I cannot say who had scribed the FIR, and I also cannot say the exact content of the FIR. Police had not examined me in this connection with this case, lordship. The scribe had not read over and explained the contents of the FIR to me.
Yes. Then what do you want?
I want a focusing of the FIR, my lord. My lord. So I
See, if the evidence has come, he has not supported the prosecution case. FIR cannot be quashed. The trial court has to take. I can't scuttle the trial at this stage. Other material may be there.
Kindly glance, ma'am. Initially, the police authority has submitted a preliminary charge sheet, my lord, keeping investigation open, my lord. Initially, the FIR was lodged against the 14%, my lord. But the charge sheet was right 14, not 22, no, 14% is lordship. Out of the at the time of initial charge sheet, my lord, he has filed charge sheet against some other 4 persons, my lord, and they have been acquitted by the trial court, my lord, basing upon the contention of the FIR, lordship, PW1, my lord. They are
The same evidence for page 33.
My lord.
So, madam, now in your case, what is happening? The trial is splitted.
No charge sheet till it filed. Only the expert, those person in which favor a charge sheet was filed, my lord, they have been acquitted, my lord. I am keeping investigation open, my lord. Till that, no further charge sheet has been filed, my lord.
So, see, I can't I don't know what kind of material they are going to collect in further investigation. I can't preempt that situation.
They are declared absconder.
That's the problem.
No.
Yes.
173(8). See, preliminary charge sheet is filed against a few people. Four people. They face the trial, they are acquitted. In the meantime, 173(8) is kept open for re-investigation, further investigation. In the further investigation, you may, because your name was there in the FIR. So therefore, you are thinking that charge sheet may be filed against you. Therefore, you are seeking a quashing of the It can't be done because the investigation is going on. I can't scuttle the investigation. Relying upon the statement of the informant in the case where the other 4 accused persons have been, When are you going to file the incident is 2023. Further
23.
23.
Cooperate with the investigation. Have you applied for
some of them bail, man? We are already ready to cooperate with the investigation.
You cooperate and let them file the charge sheet, or they may file a closure report also in view of the statement of the complainant. In that case, I'll just direct them to conclude and you cooperate. That's all. Are you on bail?
Some of them are on bail.
What about you?
I am appearing for the 9 persons, my lord.
9%.
9%.
Total 14% were named.
Total 14 persons are there on the
FIR. There are 22 working.
22.
22.
FIR.
4 persons have been charge sheeted. Preliminary charge sheet has been filed, and they have acquitted.
The petitioner, the 9 petitioners have jointly filed the present petition seeking quashing of the Titur PS case number so registered under section so. The preliminary charge sheet in the present case has been filed on
9/9/2023.
9/9/2023.
9/9/2023
against 4 accused persons out of 22 named accused persons. The said 4 accused persons have faced the trial. The learned Assistant Sessions Judge Jagat Singhpur in city case number 254 of 2023, while its judgment dated 15/4/2024 has recorded an acquittal in favor of the 4 accused those who faced the trial. The counsel for the petitioner has taken me to the statement of the informant in the before the court which is the accused persons, those who face the trial, and submits that the informant has not supported the case of the prosecution. The present 9 accused persons, petitioners, has been shown as an absconders. Further investigation in the present case under section 173(8) is pending, is pending, and the investigation is going on. Since the petitions have not cooperated with the investigation agency, the final charge sheet could not be filed. Yes.
Pursuant to in view of the amicable settlement between the parties, on the basis of that settlement, they have been acquitted.
Whatever. Congress?
না সেটা বিনেশ 4টা গ্রাম হয়ে যাবে।
Petitions have not cooperated with the investigation, as a result of which the final charge sheet, the further investigation in the present case could not be concluded, and the final charge sheet has not yet been filed. Not filed. At this stage, the petitioners are seeking indulgence of this court for quashing of the entire proceeding. I am not inclined to entertain this petition at this stage. However, the respondent state is the IO is directed to do well to see that the further investigation is concluded as expediently as possible, subject to the petitioner cooperating with the investigation agency. Yeah. With this observation, the petition is disposed. Yes. Yes. Next. 30.
I pray for an adjournment on behalf of the conducting council.
Adjourn. Yes.
31.
This matrimonial dispute only. This counterblast to the section 9 and section 13 applications.
498A.
498.
Issue notice. Issue notice, returnable and so on. So, meantime, you move application for adjournment. Okay.
Okay.
Application for adjournment to be moved by 498. Yes.
32.
Challenging the order dated 23/10/2024, my lord, I have filed this application.
Yes.
Challenging the order dated 23/10/2024, my lord, arising out of 1C1 case number 2250/2020
Yes.
for an offense under section
20%.
My lord.
Uh-huh.
143A of
Yes.
the NA Act.
Yes.
So I have filed this applications on the ground that there was no financial transaction between me and
Financial?
there was no financial transactions between me and
Why have you issued check?
I'm denying to have issued any check, my lord.
Huh?
I am denying to have issued any check in favor of the company.
Where have you said that in your complaint? In your reply to the.
Yeah, I have filed an objections, my lord. I have filed an objection. It is in case number
Yes.
in annexure 3, my lord, page 22.
Yes.
My lord, para 4, my lord, page 23, my lord.
You have issued the check. You have admitted that. Para 4.
Para 4, no, my lord.
Para 4, just read it.
The amendments made in para 1 to the petition is total.
Cost fabricated is also you were in business, and the accused and when the business failed and the monetary loss was incurred to all the partners, the complainant forced the accused persons and cunningly obtained the security check in his favor and misused the same so and so. Where is the FIR you registered?
This was, my lord, this was the term.
In all the cases, this is the usual defense.
This is the this was the business between me and my another partner.
But why have you issued the check to him?
I have not issued, my lord.
Then it has gone like this only. You have signed the check. You are not disputing the signature of check.
Actually, my lord, we were running a restaurant in Bhubaneswar. At the
all
time,
these things are your defense. All these things are your defense.
So,
what is the check amount?
It is somewhat around 6 lakhs, my lord.
6 lakhs. What are you doing?
I'm one person is doing student. Another person is businessman, my lord. The petition number 1.
You settle the dispute. Settle the dispute. I'll just simply issue notice. We'll see. Yes.
My lord, I have filed an IA.
No, simply 138, no question of stay. Yes.
33.
Okay.
I will file a copy of charge sheet to my friend. I will take it next week.
Okay. Urgent. Charge sheet copy has been placed on record. Lease the matter. Yes.
34, may I please, madam. Here I have taken a lot of cognizance. Madam, have a glance to the injury report, annexure number 2, page 14. Let's put the injury report, madam. I'm sorry, page 13, madam. Page 13, madam.
Yes.
Madam, see the last part.
Yes.
It is said, it is mentioned regarding the opinion.
307. You are attacking 307. Maybe simple, but see, where is the medical?
So far, the other part is concerned.
Where is the charge sheet? The intention part has to be seen. I don't know what kind of intention you had.
Obviously. I do consider, even if the simple nature, the intention part is to be seen.
Severe bleeding injuries.
No.
On his head.
Same part, because
being assaulted by.
Doctor said no to it. Doctor said, although it, at the initial stage it was seen to be grievous, but when I clear it, a simple injury is there.
It's a head injury.
Yes, which cannot take out. I don't two things, madam.
What have you used? Weapon?
Weapon, yes.
Huh?
Last part koila.
Genga koturi farsa fauda.
Injury again. Good injury. And admittedly civil.
Farsa? Yes, farsa.
Farsa injury can Farsa injury can.
Those things. And cognizance says, how can I go and
my humble submission, if it is assault, combined assault by
maybe see, you are armed with deadly weapon.
Yes.
Head injury is there.
Many persons.
323 earlier was there, and 307 is cognizance is taken.
Yes.
Oh, taken.
Yes.
How in a cognizance says, how will I segregate all these things?
My humble submission. Yes, of course. So for the other offences concerned, I don't dispute.
I am talking about 307.
My lord, oblige for that. So to attack the offence under section 307, my lord has to see two things. First, intention, followed by the injuries. I don't dispute that. I am not harping upon injuries first. That's why I am submitting before my lord.
See, I have to see 161 statement of the victim. Mote जीवन रे मारिया पाइन कले attack कले. Where is that those things? You have not filed anything except FIR. Where is 161 statement of the injured? I don't think beyond that I need to see.
No.
If 161 the injured says mote जीवन रे मारिया पाइन attack करते. That's enough for you to.
Then only one thing. Even if let us accept that, even if the informant say that mote जीवन मारिया पे उद्यम कले.
I'm talking about cognizance.
Yes, madam. Yes, madam. I am also to that. So, because the fact that it's a case that 3 persons by means of all sharp cutting weapons, including the other weapons, they have assaulted. Injury is 1. Madam, bear me for a moment.
In the charge says you can say corresponding injury is not there.
Madam, bear me for a moment, madam. So, if 3 persons assaulted with a common intention to take out the life of the person, injury is 1, admitted injury is 1, and that is simple. So, under such circumstances, I don't dispute the fact that my lord will not go deep into the matter. But just a mere ballot, because the affair disclose not the offense. The Bhajanlal will also squarely applicable to this because this circumstance, the honorable court cannot close his eye to this aspect, injury part.
Why have you come with some deadly weapon?
Pardon?
Why have you come
to this? Totally
why?
Pardon?
For dancing?
No. Then my lord may bear me for just
you
one more.
You came with an intention.
Then my lord may bear me for 1 second. More. It's a case that the particular the civil dispute was there, a common passage was there, which is claiming to be the of the concerned informant.
Place that charge sheet on record. What are the recovery and all everything I have to see. Mr. Chand, and counsel for the petitioner seeks to place on record the copy of the charge sheet and the statement for the witnesses recorded under 161 CRPC along with the seizure list. List the matter on. Yes, I'll just.
Yes.
Yes.
On this matter to.
Okay, 8 years.
35.
35 minutes was taken 1 week after.
Okay, on request, adjourn. Yes.
This is.
36 being 1 week after.
On request, adjourn. Yes.
May I please, my lord? My lord, this is a matrimonial dispute. Charge sheet has been submitted on section 498, 294, 323.
issue-
Matter
issue-
has
issue
been
notice.
amicably settled between the parties.
Issue
Both the spouses, they have come.
They are there already.
Yes, yes, my lord. I have called them.
Okay.
Both of them have come. My lord son is appearing for the wife.
Okay. Where is the, where is he? Where is he?
Yes, my lord. Here
He is,
Mother-in-law filed another counter case against the petitioner, her parents, her uncle, her relatives, 6 petitioners here. Thereafter, my lord, in this honorable court, in another criminal CRLMP, there was a compromise. Both parties appeared. And this honorable court directed them for release of bail and disposal of the case. But as because 306 was there, and it was not compoundable, when petitioner, this petitioner 1, adduced in support of her husband, her father-in-law, that case was disposed. As because this was 306, it was committed. And in the meantime, 7 witnesses have already been examined, including the informant. My lord may kindly see page 59. The informant, that is petitioner number 1, father-in-law, who filed the FIR, and in the meantime, he is also dead. My lord may kindly see 59.
yes. Yes, I'm there.
My lord.
Shyam Sundar Mahapatra.
My lord.
Yes.
I do not want to proceed further in this case. Exhibit 1 is the complaint petition. Exhibit 1 is my signature.
Yes.
Man, only due to misunderstanding case was filed.
That's
We
right.
cannot
I
go for
understand it.
disposal.
But the problem is now, after the witnesses have been examined, how can I exercise 482?
My lord, nothing. So far, 7 witnesses have been examined.
So therefore, the trial court will acquit you.
My lord, acquitted, but case is not being disposed. And
I'll give a direction to the trial court to dispose of.
And allow us to be represented through our lawyers. On
all these things I can't do, but I'll simply direct the trial court to
dispose within 1 to 1.
Right. Petitioner.
And kindly, and my lord may direct for sympathetically consider my 317 petition.
How do you move? That is not the cause, right?
My lord, previously,
petitioners are seeking quashing of the proceeding in ST case number 607 of 2023, pending in the court of Learned Sessions Judge Puri for alleged offences under section 306. Only 306.
My lord?
Only 306
My
or
lord.
what?
My lord.
Only 306 or anything?
That is 306 and
Tell that.
30379.
No, 306, 379,
34
IPC. Learned counsel for the petitioner has taken me to the trial in the present case is at an advanced stage. 7 witnesses out of total?
Out of total, so 12 witnesses.
12 witnesses have already been examined. Learned counsel for the petitioner taking me to the evidence of the witnesses. Try to impress upon the taking me to the evidence of the witnesses have submitted that none of the witnesses.
Just 1 minute.
1 minute, complete. Let me go. None of the witnesses have supported the case of the petitioner. Therefore, further continuation of the proceeding before the court below is a futile exercise, and therefore he seeks indulgence of this court at this stage. I have gone through the statement of the witnesses, recorded statement of all the witnesses, all the 7 witnesses, 7 witnesses. The submission made by the petitioners may be correct. To the
all these 7 witnesses, including informant,
may be correct. Correct to the extent that the witnesses, the vital witnesses to the prosecution, have not supported the prosecution. Be that as it may, since the trial is at an advanced stage, I'm not inclined to entertain a petition under 482 CRPC seeking quashing of the proceeding. It is well settled principle of law that while exercising jurisdiction under 482 CRPC, the trial court should not, the High Court should not scuttle the ongoing trial, particularly when the trial is at advanced stage. Therefore, the petition deserves no merit. Hence, the same is.
Young lady should be married, my lord.
However, liberty is granted. However, keeping in view the peculiarity of the present case, the trial
To facilitate her marriage.
trial court is directed to do and to see that the trial is completed as expeditiously possible. At this stage, the counsel for the petitioner submits that few of the petitioners are senior citizens.
My lord.
Senior citizens. They may be exempted from personal appearance.
Widow, my lord. Petitioner one is widow.
Not acceding to the request made by the petitioner. However, liberty is granted to the petitioner to move such application to court.
Well, within 2 months, my lord, we can death.
I'll modify it. Okay. Yes, next.
Much obliged, my lord.
May I please, Your Lord?
Yes.
My lord, here the petitioner took a hand loan from the informant, my lord, of 5 lakhs and given some blank checks as security, my lord. And later the informant alleged that those security checks were stolen from his house, my lord, her house, my lord. Now the matter is in a verge to compromise, my lord. They have already amicably settled, my lord.
What happened to that check? The check which was given by you allegedly, taken by you allegedly. Have you filed 138 case?
No one.
138.
Where are they?
Check has been
Where are they?
Para 2 they have stated in.
138 case is there.
No, my lord. Not there, my lord.
Have you initiated? You should tell me the real facts. What are the facts? No clue.
Para 2, he had stated that, however, as
See, the allegation is the check has been stolen.
My lord.
Whether that check is used and whether that check, in lieu of that check, any case is pending.
No, my lord. Those, as per my information, those checks are
Not information. You have. This is the vital information you have not asked to your client. This is the facts. Don't make statement without knowing things in the court, particularly. You must ask your client whether any 138 matter is pending. If that matter is pending, if you are settling both the matters to be settled. Did you follow what I'm trying to tell you? See, there is a theft case now against you. Theft of what? Theft of the check. Whether you have deposited that check.
No, those checks are my check only, my lord.
Whether that check was deposited by either you or him, whatever.
No, my lord.
No, how are you saying no? You have not said anything in the petition.
in paragraph
I ask the question, you have to say no, you say no. That's all. Without asking your client. And tomorrow something happened, then you say that I'm so sorry. You say that way, you tell, you seek instruction. I'm just adjourning it, you seek instruction. I'll issue notice. Okay, I'll issue notice. Seek instruction regarding that also. Okay. Simply issue notice. Yes. Yes.
40 withdraw.
40 withdraw. Yes.
41.
Yes, sir.
Petitioner is the husband, and he has filed CRMC challenging the award of maintenance in favor of the wife on the ground. The wife is living in adultery and living with his third persons, and since 2 to 3 years he is not even in the house of the petitioner or with the parents, and living with another person and filing this maintenance, and that has been awarded.
Where from you,
yes.
Where from I get that living with
Yes, Annex 1 and 2. One brother of the my wife, Millard, has reported the matter to the PS. That she has left with another person by leaving her small child. The one brother has
I'll issue notice.
Annex 1.
Okay,
Annex 1.
issue
Notice, please.
Issue notice. Yes, next. 42.
42.
Yes. Okay.
Yes, I am for the petitioner, sir. I prefer adjournment.
Yes, sir.
Sir, I am for the petitioner. I prefer adjournment, sir.
Okay, adjourn. Then counsel for the petition seeks an adjournment. Adjourn. Yes. 43. 43. Yes. You are appearing 44. Okay, 43. Simply adjourn now then. None appears. Yes. Either I'm at 44.
Might please, Here the petitioner challenging the proceeding. Case diary may be required in this matter. State counsel.
You are challenging proceeding, they will supply you the annexure.
No, if case diary is required, then
What are the offences?
the offense is, my lord, 409, 468, 470, 420. The perjury connotation altogether is different, my lord. What happened in this matter, your lordship, 5 accused are there. The allegation is like that, my lord. They misappropriate the fund of from some of the beneficiaries. So, my lord.
Why are you seeing him? You are addressing. You are sure that you don't have a case, it seems. Tell me, what are the allegations?
My lord, your lordship simply.
Are you depending upon him now?
No, my lord.
Do you want an adjournment? I'll give you.
Your lordship, kindly
I'll
adjourn
adjourn
this
it.
matter
You
because-
prepare and come, huh? Okay.
Because
Simply
charge sheet is already submitted, your lordship. So
I'll just issue notice because
My
he
lord,
is heavily
check
depending
that
upon
I-
you.
My lord.
Maybe something happened. I'm just issuing notice. Okay?
My lord.
grateful, man.
Kindly CD may be called for also. Case diary.
This is the internal understanding. Yeah, CD call.
Grateful, man.
Yes.
45.
Yes. Yes, madam. Pass over. Okay. Yes. Okay. Copy of the petition, advance copy of the petition has been supplied to for the Mr. Maharana today. Leaves the matter for hearing.
46.
46.
May please, your lordships.
Yes.
Lord, this is the charge sheet has been filed in 2022. The offences are under 420, 467, 471 and under the OPID code and the Price Cheats Act.
Yes.
Lords, but what has happened is a question of law here. The said company, as against the company, proceedings under the SEBI Act had taken place under Section 11. Post that, an interim order was passed. The allegation against the company is that the company would issue NCDs, non-convertible debentures.
Yes.
Simply speaking, my lords, a NCD is in the nature of a fixed deposit. It is nowhere come out in the charge sheet because the charge sheet has been filed today. Under the SEBI Act, I have suffered an order, which is an order under Section 11, Section 73 of the Companies Act. I have suffered that order. That order is of 2016. As against that order, I have not preferred any appeal or anything. So that order has attained finality qua me today. Now, what has happened subsequent thereto, kindly see the charge sheet. The charge sheet now, which is at page, it starts from 34. The relevant portion, I'll take my lord's case.
Yes.
I am one, which is at page 84, Pratap Kumar Biswal. He is the one who's moved the 482 petition.
Yes.
Kindly come to page 102.
102, yes.
102.
Yes.
This is the crux of the matter.
Mm.
The other parts of 18.14, 18.15, in fact, start if my lords would come to page 101.
Yes.
The allegations against me. 18.12, I'll just quickly go through this.
Investigation of the case further review.
Yes, my lords. That I am Pratap Biswal, that along with other directors, I have defaulted to return the principal amount of deposit and I am liable for prosecution under Section 6 of the OPID code, my lords. The subsequent one is that I was not registered under the RBI Act under 45(1)(a) of the RBI Act, and so that's also attracted. As against all of this, kindly come to, just before I finish, before I read the charge sheet further, kindly come to the SEBI order, which is at page 137.
137, okay.
I have suffered the SEBI order. In view of this SEBI order, my lords, there is a judgment of the Supreme Court which says that if a prosecution is launched under section 26 of the SEBI Act, then it says that it would be under the SEBI code only. Because there is also a judgment of this act, which is that under the SEBI, because that's of Justice Lodha, while he sat.
What are you trying to say? You are saying, since I suffered SEBI, so no 6.
No 6
That's
will
what
today
you are-
apply. And today, what do they say? Total amount that I have duped is of 2 crore 85 lakhs, which is at page 102. That's the total money which they have suffered. And under the 456, I can demonstrate today nothing substantial other than these two. And what has happened is
how many complaints against you?
There is only one complaint. One Sukhadev Hota files an FIR. That's what I've seen, owing to which this charge sheet has come into being.
Who is there for EOW? How many cases, how many complaints are there against you? That's come to the substance.
My lords, to my
This
knowledge-
technicality may
All right,
work
my
for
lord, I agree. Kindly then, my lords, there is only one FIR pursuant to which this FIR, by one Sukhadev Hota, that FIR also have annexed, which is of 38/2019. Kindly
I just
see.
issue notice, let us see. Let us find out how many complaints are there against you.
All right, my lords.
Under you can't hide.
No, I can't come under any cloak of.
Yes.
But my lords, if the SEBI Act applies, then maybe this act. That's a question for consideration. Finally,
Do you have any judgment?
Yes, my lords, I have.
To me, if once you suffered a SEBI proceeding, you are precluded from any other offense like the section 6.
My lord, that is not an interplay between section 6 and SEBI Act, to be fair to the court. It generally considers that once a prosecution is launched under SEBI offenses and a SEBI court is there, so the designated court there would be under the SEBI Act and the SEBI court. This court will have no jurisdiction. So
Then on facts you have to see whether on the same facts, on the same allegation.
Exactly. That's why, my lords, kindly I will show from the SEBI order, as well as let them come. I have no issues from the SEBI order. I'll show that. I am not shying away. That under the SEBI Act and this, it's only the NCDs which were issued. The bungling, which the allegation that which I have done, that I've given NCDs. NCDs are not shares. They are like fixed deposits.
Then what are the precise allegation against you? You have
Precise
issued the NCD.
allegation is, which even this FIR says, one Sukhadev Hota, who's of Soro, Baleswar, says that about 3-4 dates, 30,000, 20,000, around some 90 or 1 lakh rupees is what he has said is totally the amount which Sukhadev Hota was duped of. So that was the FIR which started this. After that, if investigation has further revealed is what the charge sheet says. So obviously there must be other investors for which that would have come to 285 today. So today, my lord, what has happened is the proceedings are on. What I'm requesting is, if otherwise we'll move for an adjournment there and keep it on a shorter date. Let this point be considered.
Who is appealing?
I have no issue.
EOW who is appealing?
We have served on Mr. Bhuiya.
OPAD, Mr. Bhuiya. Mr. Otto Panigrai, Senior Counsel, appearing for the petitioner, submits that the petitioners have already suffered the SEBI proceeding. Where is that order SEBI?
My lords, that order is at page 137, order dated 25/4/2016.
Annexure?
Annexure 11, my lords.
11. SEBI proceeding on the self-same allegation. Since the petitioner has not challenged the order dated, when is the SEBI order?
My lords, 25 April 2016.
25 under separation passed by the SEBI board. SEBI, which is at finality. The proceeding initiated by the prosecution, particularly for offense under section 6 of OPID Act, is forbidden under forbidden under law. He relies upon the judgment of the Honorable Supreme Court reported in 2018, 13 SEC 1. SEBI versus Classic Credit Limited.
Paras 57 to 59 to be precise.
57 to 59. Reproduce for 57 to 59. On the strength of the aforementioned judgment of the Honorable Supreme Court, he says that at least the petitioner cannot be prosecuted for alleged offence punishable under section 6 of OPDID Act.
My lords,
If you
along with
notice,
6, also 420 is also attached, 420, 460.
then no offence is made out, then according to you, merely because you
My
suffered.
lords, if I am able to show to
And,
my lords, that then obviously, and if I am not.
Section 6 and
along with
other
that,
allied offence also.
allied offence, under the
offences-
IPC.
Offences under penal.
Under the
also,
IPC.
penal code also. Issue notice, I'm issue only, I recording your statement, issuing notice. Issue notice to opposite the EOW. And on instruction, Mr. Panigrahi submits that the advance copy of the petition has already been supplied to EOW counsel. However, none appears for the EOW. Issue notice written within 2 weeks. In the meantime, petitioner may move application before the trial court seeking an adjournment before the trial court owing to the fact that the matter is sub judice before this court. Yes. Ready the petition. Yes. Yes.
47. My lords, can I request for a return of the date?
He'll give a date.
Okay.
Yes.
The accused in the 138 NIX case.
Yes.
An order has been passed under section 143A of the NIX.
What is check amount?
That, yes, to give a interim compensation 20% of the.
What is the check amount?
13,70,000.
Okay. What is wrong in it? Have you issued the check or not?
No, I say that I have issued the check. And let me give the background facts. I was president of the managing committee of private schools. Now, on the allegation that I have misappropriated the funds of the school, that a GR case is pending. I was arrested there, and as a condition for my bail, this honorable court unfortunately directed me to deposit rupees 15 lakhs, which I have deposited. The check amount is 13,70,000. Now, the case is that towards the repayment of that misappropriated amount, I utilized. That is it. So this allegation is dependent on the other case.
But pursuant to the High Court order, you have given the check. Then?
So now.
See, then you are not disputing the fact that you have issued check.
No.
Then
the case is that I was forced to issue that.
No. High Court order, how can you say?
No. High Court order, I mean, the other members of the managing committee forced me.
That's the main case, that GR case, that's I understand it. But what was the occasion for you to issue a check? Occasion is the High Court granted you bail with a condition that you have to deposit.
That 15 lakh I have deposited. This 13,70,000 I issued check to the managing committee towards refunding the misappropriated amount.
What is the misappropriated amount? Total?
17 lakhs this year.
The 15 lakhs you have paid.
Yes.
A deposit of 73 lakhs here. Who will settle the dispute? Total amount is 17 lakhs. 15 you have paid and pay the rest of the amount to finish it up. That GR case and everything will be finished.
Not in the position we learned that.
That's right, but you today, you see, you have to 15 lakhs you have already paid. Wrong, right, whatever.
Yes.
Now you have issued check of 13 lakhs something.
So that is
total misappropriated. Okay, total misappropriated amount 17 lakhs.
That is to be decided there. There is absolutely no evidence of any entrustment.
You can earn from that same institution. What is it? You can earn from that same institution where you are president. You remain president again. You will earn money. 10. I will reduce you to 10%.
No, you're not kindly speaking.
Okay, I'll issue notice. Let us issue notice. Okay.
Stay of the order.
No, stay. I'll not stay. Let it go on. What is the big deal about?
The impute order of deposit of that 20 lakh, that 3,40,000. Or
what will happen if I will not say?
I have to deposit it within 60 days.
If I sub judice before this court, who is insisting you to deposit? I'm examining that issue. Who is insisting to you deposit? Trial will go on.
I'll go on. I'm not.
No, I'm examining it. This issue is
direction to deposit that amount.
What is going to happen if I am examining it?
They would take out a proceeding for.
No, how can they do it? I'm examining it. How can they do it like this? Yes, I am issuing notice. They will not do it. But try and settle it. Pay something and finish it up. Both the 138 GR case, everything will go.
I thought that I was the president. I was not.
I understand, but you try to appreciate one thing. 15 lakhs you have already paid. I don't know how many years it will take for in trial. Your money is already stuck.
15 lakhs, he had to pay because he was in custody.
But your money is, but wrong or right, whatever, money is stuck now. Money, your 15 lakhs is stuck.
Yes.
For I don't know how many years. And you at least you pay it and finish up and get rid of both the cases. That's the real approach. Sometimes it happens what to do. Think over. Okay. Yes.
48.
May I please, Your Lordship? I'm appearing in virtual mode, my lord.
Yes.
Lords, this is a case which is spring out of matrimonial disputes, my lords. The petitioner number 1 disputes, my lords.
Matrimonial.
Yes, matrimonial dispute.
Yeah.
And the petitioner number 1 is the husband. Petitioner number 2 is the father-in-law of the informant. Petitioner number.
How would it be in this?
Petitioner number 3 is the mother-in-law of the.
1 minute. Section 85. Yes. Tell me.
In this case, the petitioner number 1 is the husband of the informant, Mullahs. Petitioner number 2
Okay, issue notice.
Mullahs have also filed an IA seeking directions for no coercive action against these petitions because the petition number 2 and 3 and 4. 2 and 3 are the old age ailing father-in-law and mother-in-law of the informant.
Why don't you apply for bail? These are 498 cases. You get bail. What is the
but we have challenged the very foundation of the FIR, my lords.
Merely because it is a matrimonial dispute, therefore I am issuing notice. If you want me to get into the merits, you may not have a case. So I am just issuing notice.
The entire allegation is generalized and sweeping allegation, my lords. If the annexure 1 is the FIR, my lords. At page number 20 to 25, if your lordship will peruse, there is no particular allegation against any of the petitioners, my lords.
Issue notice for the let him move application. Matrimonial dispute, let him.
No coercive action, my lords. No coercive action against these petitioners, my lords. Till next date, my lords.
Yes, next.
Petitioner या advocate? Petitioner या advocate?
Advocate. 1 minute. Is he practicing advocate?
Yes, he is a practicing advocate.
What do you say? No coercive. Matrimonial
dispute. Petition number 2 and 3 are the old age.
Conciliation has been, my lord, cancelled.
They
are conciliation already cancelled.
Yes. There is a divorce proceeding
going on.
Do
not desire to keep her as wife.
There is a divorce proceeding going on in the family.
Why don't you pay something and finish it up? You have to pay.
Let the situation comes, my lord. But now they are taking a different.
Okay. I'll send it to mediation. Okay. District court.
No coercive action, my lord.
Okay. Right. Where is the FIR?
FIR is
page 20 to 25.
Being matrimonial dispute, parties are referred to district mediation center, Bolangir to explore the possibility of a settlement. In the meantime, no coercive actions are
being taken. May I please, Bolangir is 80 kilometers away, and my parents is not in a position to move because they are heart patients. They have other diseases,
You can't have both. No. You can come to the. You can come to High Court. There also you can do it virtually. High Court is over. Yes. Next.
That direction will kindly pass, my lords. Virtually we will appear.
Yes.
Till that no coercive action.
If so required, virtually. Yeah. If so required, virtually. Yes.
Till that.
Only senior citizens virtually, but argument to go. Yes.
That's the item 49. So the appellant has convicted RI for 3 years.
3 years. Admit. 3 years. Admit and yes.
IA number.
Yes. Allowed.
I may be pardoned, my lord. This appeal may kindly be listed along with CRLA 279 of 25 and 265 of 25.
10. Yes.
Seven active persons are there. 7. Total 7.
Allowed. You are all applications are allowed. Yes.
50.
50.
4 years. And in
4 years.
cost.
Okay. Bail granted. Realization of the fine. Paid and yes.
My appearance में kind
Mr. Das appears. Yes.
obliged one.
Yes.
51.
16-8 to
Annexure 1, page 7 Miller.
Yes. Tell me the dates. Tell me the dates only.
NBW my lord 9/4/19
And
bail 16/8/11
Where because it's on the
16?
8/11 my lord 2011
16/8/2011. 1000. Yes.
52.
52 my lord bail 4/6/19 2019 NBW my lord 25/7/23
Okay. 500 each.
53.
53 my lord bail 2/8/2011 NBW 8/10/2024
24. 500. Yes.
54.
54, my lord, I am challenging the order dated 6/4/2022. Previous bail was on 18/4/2019, my lord.
1000. Yes.
6/4/2022.
1000. Yes.
That's true.
55.
NBW issued on 12/9/24 and it was granted bail on 4/11/2016.
Okay. 500.
56.
My lord, NBW issued on 9/5/2024. He was granted bail on 11/5/2017.
500. Yes.
57.
NBW was issued on 11/12/2020.
Hmm?
NBW was issued on 11/12/2020. And it is out of the complaint case 138 NI amount.
2020. NIA told. NIA. NIA told you 500. Yes.
58.
Yes. 58. Service. Huh? Let us see the service. Notice was issued in 2016.
Yes. The party number 2000 that they have written Panlakam and my lordship, I have received a letter from the person that it is coming under Victor. The address is wrong, therefore the notice is not published.
Trace address to be furnished. Notice was issued on 26/4/2016, which could not be served due to insufficient address of opposite party. Number. He is Tahsildar Paralakumdi. Yes. What is the problem?
It was not Parlakamandi, my lordship, they have given us that it is Bettaguda, which is coming under the Gumma Tahsil.
Gumma. That's
Yes.
it. Mr. Sarita Marana, Legal Counsel for the respondent says that the address of opposite party number 2 is wrong. In fact, the opposite, the Tahsildar Gumma. Bettaguda Gumma is the relevant party to the proceeding. The petitioner to amend the remanded memo of the party and on issue notice to opposite party. Opposite party is this year. Yes. What is the main matter about?
It is the correction of R.
Okay.
They have filed one section 152 for the amendment of R. If I may lordship review, this is a review petition, so covered by your last judgment.
They do have covered.
And delay is my lordship 733 delay for filing of appeal and 176 delay of filing of the review petition.
Okay. Have you changed it?
Yes, only 2 changes.
Very much. Delay. FAO delay kete?
Oh, 733.
733 days. Huh?
Yes, and the review petition is 176 days.
Review petition?
176.
176 days. Yes.
May we have I'm appearing on behalf of the opposite party. That member.
You did. Yes.
60.
Yes, sir.
The Honorable Appellate Court has given a direction
What direction? Because of the official petitioner, it is noted that the respondent also said with the notation.
By the time the review was already.
Having heard that the record including the appeal order as well as the judgment of the first court and the term we find that an opportunity must be given to the petitioner to seek an appointment with the press commissioners to measure the circuit's range. In these circumstances, we disclose petition pursuant to the Supreme Court pursuant to the order dated 10/2/2025 passed by the Honorable Supreme Court in specially petition SLP civil number 15654 of 2023, granting liberty to the petitioner to file the present review petition, the present petition has been prepared by the petitioner, issue notice to opposite party, written
Pardon, my lord, item 58, my lord, I have filed an IA for succession. That means
That's CMP matter.
That's
CMP.
Again, my boss को जाने करने से state
अच्छा 2016 matter, is there anything survive? Okay. Which application?
That I, my lord, 957.
For the reason stated in the application, the same is allowed. Petitioner is allowed to bring on record the LR for opposite party number. Petitioner.
But there petitioner now the LR of the petitioner 1 to 5.
LR of petitioner 1 to 5. Yes.
I will file the
Amendment and memo parties to be filed within a week. Yes.
61.
And you change this address also.
My lord.
Tahsildar Parlakundi is there. Tahsildar Guma. Guma. Because ROR is that area. Yes.
May I please explain?
60?
61.
Yes.
Explain.
Yes, sir.
Last occasion, sir, Land Council for the petitions granted liberty impel the enforcement direct to opposite number 2. I have, sir, I filed all the requisites.
Opposite party number 2. Service.
Yes. I don't know. Item number 61.
Yes.
Yes. Implemented EP as opposite party to lately, so
Acha. Service is not complete. Service on opposite party number 2 is not complete. Huh?
Versus stay.
Sorry? ED party को आपने late college इतने ही.
No, sir, late. No, only do this.
Whatever, that is the report.
I have received that certificate copy.
Okay, anyway, now service on opposite party number 2 could not be affected as the opposite parties belatedly impleaded in the petition pursuant to the direction of this court. Fresh step to be taken by the petitioner to serve opposite party number 2 referendum. Yes. ED हो vigilance कर दीजिए. Yes.
62.
Yes, sir, I will file a requisition. Again, I am giving this.
I am receiving the notice.
ED आपने ED पे.
ED, yes.
And don't accept notice for advance notice for ED. Appearance लोगों देखो. Service को जनरल खत्म. ठीक.
62.
Advance notice. So, yes, 62. The request of the petitioner. Yes, what is this matter?
79, 506, 307 and 34 is there. And they are stating that they want to compromise the matter.
See, the first the matter, I'll tell you how many hearing has gone like this. As requested, 27/8/2024, adjourn on request. And again, 7/10/2024, none appeared. And next again, it is taken up on 19/12/2024 on request again, adjourned. How many hearing? You settle them, settle, bring them. Pass or dismiss. Second call, if they don't come, I'll dismiss that. Yes, 63.
If the Lordship had directed to dispose of the trial with the order dated 14th of March 2024.
Yes.
Letter has been received from the learned court.
What was the order? The
trial be disposed of expeditiously
Yes,
within
yes.
6 months.
Application has come. Okay. Application come pursuant to the order dated in a wide order dated 14/3/2024. This court directed the trial court to conclude the trial as expeditiously as possible, preferably within 6 months. 6 months. The trial court, learned trial court, the third additional sessions judge Barampur has now requested this court to extend the time for disposal of the ST case number 65 of 2013 for a period of 3 months. For a period of 3 months. For the reasons stated in the application dated letter dated 28/2/2025 issued by the learned sessions judge Barampur. The request made therein is accepted, and further period of 4 months is granted to the trial court to conclude the trial. 4 months, 5 months, further 6 months also for the 6 months. 3 months, 6 months.
64.
My lord, in this case, I humbly submit that there is admittedly civil suit and IA is pending. My humble submission, let that be decided without being influenced by the order to be passed in this case.
No, what are you asking here?
My lord, in this case, I initiated 145 CRPC proceeding. The learned magistrate held that he lacks jurisdiction to entertain the same. So I challenged that before the learned district and session judge. He also confirmed that. For that, I have filed this case. My humble submission, irrespective of right title interest, the possession of a party is to be declared forbidding others from interfering with the possession. This is the scope of 145 of the CRPC. But the learned magistrate held that he lacks jurisdiction. For that, at the admission stage, I cited a decision. Referring to that decision, my lord issued notice. So, in the meantime, there is suit is pending, IA is pending, and they filed another case that has been disposed of by this Hon'Ble court 2 days ago, holding that since civil matter is pending, it is to be decided there.
The civil court will decide.
So, my humble submission that that is to be the parties will pursue their legal remedy there without being influenced by the order to be passed by this Hon'Ble court.
The finding given by the executive magistrate in 145 is not binding on them. Civil court has to decide on its own. Why should I give that?
My humble submission to be passed in this case pending before this Hon'Ble court. In this present CRMC, whatever will be the order, I do not know, but my humble submission that it will not affect my pending
civil right, civil suit. It will never. It is an independent proceeding.
Order will be passed on that account.
Unnecessary, these observations are creating confusion.
Yes.
Both the proceedings goes in a parallel direction. And your right title and interest, possession and everything will be decided in the civil suit. These 145 proceedings are an interregnum arrangement. Because peace and tranquility in the area is affected. So therefore, it is a kind of...
as the learned magistrate held that he lacks jurisdiction, for that I went in revision. Revisional court also held that contrary to the reported decision of our Hon'Ble High Court. So for that I have challenged this. So now the latest development that there is a suit and IA pending.
Subsequent thereto suit has been filed. Subsequent thereto you filed the suit.
I filed.
When you filed the suit?
It is a matter between the two
when have you filed the suit? After the impugn order?
No. After the
Page 18.
18,
80.
80. Yes.
This, at the bottom, this
Hmm.
order was challenged before the session judge. At the bottom, page 80.
Yes.
At the bottom.
Hmm.
In the view of the above facts and circumstances, this court opined that the dispute between the parties is purely civil in nature, and as it leads to lease agreement, etc., etc. All these facts can only be adjudicated before competent civil court.
That's what.
And that has been confirmed at the session.
What is wrong?
No, I am not that on that. My lord, my humble submission, irrespective of the right that.
No, where have you read that? Per page?
80 last.
80.
80 last.
80.
Page 80.
80.
In view of the above facts and circumstances.
That was the order of
the executive magistrate.
Executive magistrate.
No.
I'll just see that in view of this observation, now the suit has been filed, so I'm not interfering. As simple as that.
Yes, that
Why
is,
should I get into all
that
this?
is the only thing that your lordship will pass.
I'll just write down. Petitioner, the petitioner has initiated a proceeding under section 145 CRPC. The trial court has dismissed the application. Inter alia observing as under. Para 80 ne jo reproduce korchundi na in view of. Para 80 reproduce koriya part. Further. This magistrate in nutshell had arrived at a conclusion that the intrastate dispute between the parties could only be settled through a civil proceeding. The said observation, said dismissal order passed by the magistrate was said by the petitioner by filing criminal revision number 100 up to 2024 before the related sessions Cuttack. The related sessions Cuttack, by its judgment dated 22/10/2024, has upheld the findings recorded by the magistrate. Let counsel for the petitioner submits that now a civil suit has already been filed by the petitioner.
No.
He submits that a civil suit between interested parties pending.
In the court of the civil senior division, passport cutter.
In view of the observation made by the magistrate, which has been upheld by the learned sessions court, I am of the considered view that no interference is called for. The dispute, interstate dispute between the parties would be obviously settled by the civil court in the civil proceeding without being influenced by any observation made by either the sessions court or the magistrate. Yes. With this observation, petition is disposed. Yes.
65.
An application for appropriate orders, my lord. On 21/3/2020, my lord, learned court will allow the petition under section 205 of CRPC, my lord. Thereafter, inimitable on 205 was allowed, my lord. Before learned court below. Inimitable was issued on 29/24, my lord. Thereafter, the petitioner preferred criminal miscase, my lord, and this honorable court directed the execution of the order dated 29/24 passed by the learned JMSC Balesar in non-cis case number 8 shall kept in abeyance till 15/12/24. Subject the petitioner appearing before the court below on or before 15/12/24, my lord. As per direction of this honorable court, my lord, petitioner appear before the court below on 13/12/24, my lord. I have filed that order, my lord.
Now what do you want?
Learned court below was pleased to put up this matter for further orders. PO is on leave. Thereafter, the date has already been elapsed, my lord. And learned court below on 6/1/25, my lord, adjourn the case for production of the petitioner, my lord. Not disposing that application. I have filed that application on 13/12/24, my lord. Lords may kindly see page 10, my lord.
Yes. 10 of your application.
Page 10, the learned court below directed counsel of the accused filed a money receipt showing 500 rupees as per direction of this court. 205 CRPC is not, sir. Put up CL for PO for further orders. Further orders thereafter, my lord, 2/2025, my lord, case was adjourned, and 6/25, my lord, put up on for production, my lord.
So why then what is
Lordship, my lord, extend the order dated 22/11/24, my lord, and directed the petitioner to appear before the learned court below.
You appear, but who stops you?
Little many extent that NBW order is there, my lord.
NBW
Lord's court below directed for put up on 3/4/24 for production.
NBW was
Yeah.
caused by this honorable court, and the honorable court
Yes,
directed.
Understand.
But he didn't have,
And
he,
the PO is a lead.
yes,
So he wants that it should be extended.
Thereafter, the period has already been over, my
I
lord.
understand. Right.
Lord, we can extend it.
Okay, by the order dated 22/11/2024, this court direct I लिखो I number कौन सा?
My lord,
Find it.
IN number 595, my lord.
595. This court by the order dated 22/11/2024 directed the petitioner to cancel the NBW issued against the petitioner and directed the petitioner to appear before the trial court on or before 15/12/2024. Till that day, the execution of NBW issued against him was stayed. 13/12/2024, the petitioner appeared, surrender before the trial court. However, on that day, the PO was on leave and the application moved by him could not be decided. Confronted with that situation, the petitioner has moved the present application seeking extension of time for surrendering before the court below. On instruction, he submits that his client would be appearing on the next date appearing before the trial court. Till then, the execution of NBW issued against him shall be stayed. What is the next date appearing?
Next date appearing, my lord, 3/4/25, my lord.
The next date appearing before the trial
For
court
production.
fixed on
3/4/25.
On instruction, he submits that on that day the petitioner would be appearing before the court.
Till disposal of the petition dated 13/4/2024, my lord.
Till then, the execution of NBW issued by the so-and-so shall remain stayed. Yes. I've stayed the end. Okay.
66.
this is also the.
I will for the modification on date of 22/1/2021 in place of the 24/4/2024.
Sorry, I didn't follow you. What do you want?
My lord, date पर change करो NBW issuing date. NBW issuing date.
NBW के भाई 25.
My lord,
24.
22/1/2021.
Just see your prayer in the
Yes.
petition. What have you written? If you have written this order, date 25/4/2024, obviously I'll write that only.
Typical
You
mistake.
commit the mistake in your petition, you want correction of my order.
No, my lordship.
No.
Actually, the first NBW was issued on 22/1.
See the prayer.
Yes, my
The
lordship.
prayer he writes 25/4/2024. Now he says that it should be 22. That's the problem. And Annexure 1, just see Annexure 1. Annexure 1. 25 only Annexure 1.
NBW was.
Where from you
issued-
got that order? NBW was issued on 25/4/2024.
They want to extend the NBW order because my lordship, he was saying the plea he has taken that I am in the Surat. So on the date when I have to surrender, first actually NBW was issued. Then this honorable court has to quash that NBW. He has to surrender before the on the date fixed. He has to surrender before the court below, but he didn't surrender because he was in Surat. That they have taken in the plea.
But he wants a correction of the order.
That
What exactly you want? You tell me. Is he correct?
Melodic correction that 22/1/2020.
You are wrong, sir. Just see your NBW order which you have placed on record. That date shows 25/4/2024. Correct. The order is correct. Where from you got that order 22?
Yes, my lord.
In the prayer also you have written the same thing. And you have filed the certified copy of the order.
yes.
That order shows
Yeah,
25/4/2024. Why do you want correction?
My lord, this order will. My lord, this order will be
Which order, sir? Then you might have filed something else. I don't know. What kind of. This is a separate order. This is a separate order. Just see the annexure in your petition, which you have filed already. I have to go by that annexure or some other order. Then you file a fresh petition challenging this. I can't correct it. Because in the prayer you have written the same thing, in the front page you have written the same thing, annexure also, certified copy of annexure you got. সেটা দেখিও কাউকে petition ফাইল করে তো নিয়ে যায় না order দেখিও
মুন্না জেনা তো
মুন্না জানা
this is which case here case CORAM case
28 of 2018.
this is file number. Oh, then you are not able to understand what exactly is it. The earlier on 22, here also the dates are different. 22/1/2021 NBW was issued, which was not executed. Subsequently, another NBW was reiterated because it's not executed, reiterated on 25/4/2024. That order goes already. If we, in view of the fresh NBW issued, the order is correct. Why are you seeking correction? The earlier this order was passed, it was not executed, therefore a fresh NBW was issued. That NBW I quashed. Why are you don't do that, huh? Don't do that.
Okay.
Don't do that. This is correct order. You will be in trouble.
Okay.
If you have any problem, subsequently tell me. Okay. Simply withdraw.
Okay.
Review. 68? 67, 67.
From the noting, your lordship will see that the counter has been filed without a copy serving on me. I am for the petitioner, madam. My interim application is pending. That is for extension of the interim order.
See, this is pending since 2017.
Matter is pending. So, lordship may fix a date. It will.
No, what is this matter is about?
This is allowing amendment. Contrary to the proviso to the provision of order 6/17, that hearing commenced, 2 of the witnesses have been examined. Thereafter, amendment was sought for, and it was allowed.
And for the plaintiff.
The suit was, the proceeding suit was stayed.
Yes.
2017.
What is your authority?
You know, counter copy that they don't do.
And now after 2017, now the issue is whether counter copy is supplied or not. That I will
They have
decide.
not given it, but from the noting, it is seen that they have.
Just appreciate whose suit. It is your suit or defendant? You are defendant.
I am the plaintiff.
And why have you kept it pending for such a long time? He is seeking amendment this way or that way. The suit is, the proceeding is stayed.
During pendency of the suit, subsequent events happened. Therefore, I filed the amendment petition. Court allowed it.
He challenged it.
He challenged.
Got a stay.
Got a stay.
2017.
Yes.
And happily enjoying, you are not interested. Is there anything survives in the suit?
Suit is from that day it is stayed. Suit is pending there.
What suit? Is it
It is
declared?
suit for
suit?
permanent injunction and mandatory injunction. Mandatory injunction prayer.
I don't think there must be anything.
There is a common passage.
So it is,
You just tell me whether
Allegation is
anything
the-
subsists in the suit or.
Yes, yes. Because suit is now pending, 2 witnesses has already been examined.
after the petition is filed. After examination of the witnesses, they file the application.
Yes, it is also
And,
permissible.
and your lordship will see that the second prayer is for mandatory injunction. Is there any construction or anything, any sort of?
Are you seriously opposing the amendment?
Amendment? Because my right is going to be prejudiced. I will, if your lordship may kindly allow the chance of hearing to me, I will clarify.
Okay, supply the copy.
Yes.
I think the plaintiff is not interested in his suit. Like 2017 report, he is not interested now. What to do? Yes. Copy of the petition.
Counter copy, lordship may kindly.
Copy, you exchange the copy. Exchange the copy, please.
Yes, during course of the day, I will give him, fix a date, my lord, so that.
He'll fix a date. 2017, you have not taken interest in it. Yes, anyway. 68.
Interim order to continue.
Entry mode to continue. Yes.
Your lordship may take it up for lunch. Take some time.
Yes.
Post lunch, your lordship may take it up.
Ah, okay. After lunch.
Afterwards, my lord, I don't know.
He has some problem after lunch.
Your lordship,
Next week.
I am ready. I am ready right now, but it's already 1:20.
Okay,
I
it's all
don't want
right.
to
Because he has some problem. We'll give it. I'll give a date. I'll see it and I'll give a date.
Your lordship may take it up tomorrow.
Tomorrow may not be a problem because the assignment is now changed. I don't know how to adjust it. That's
As your lordship.
responsibility has come now. Let us see.
Item number.
I'll just check it up and adjust it.
As your lordship.
72, my lord.
Yes.
72 notices were issued to the informant. Twice I had taken notice to the informant. On 10th of January.
Addressee left.
Addressee left. So you have directed the council to take notice through the IAC. I suppose he has not received it.
No, you have not received.
No, he is not.
Notice were directed
He is
to
not.
serve through IAC.
72.
72.
72, yes. My, today morning we have received information.
Okay.
So let the matter be adjourned.
Right. Notice was directed to be issued to the opposite party number 2 through IAC. The state council submits that he has not got the information as yet regarding the position of service. Leaves the matter on council. Entry mode to continue.
Interim order.
Entry. Yes.
But at serial number 73, that matter is pending before Supreme Court. The Rasmita Patra, your lordship remembers the OPID, whether OPID Act will be applicable to the RERA.
Simply adjourned. Simply adjourned.
Interim order was there, my lord.
Entry mode to continue.
Obviously.
Next week, 17 or 18.
Who is appearing against you? You are appearing. On the ground of personal.
But I'm only praying, man, it may be next week, but
I'll see. Okay. I'll see that. Adjust. Next week, the review. 17 wala we get the. See, and in that week I'll get.
The next matter 69.
Yes, sir.
The next matter is 16.
Maybe 17. Subject to your
Now 17th will be tough. 17th will be very tough. Let it be on 2021 anytime.
Yes, 20, maybe on
20.
Yes.
Yes, sir.
The very next matter, that 69.
Yes, sir.
There the state was to produce some documents.
Do you have any instruction?
My lord, already the document I have obtained and it is found that there is Borma Mamuli. Borma Mamuli boli achi seta khali dekhiବାକୁ ଚାହିଁଥିଲେ. Otherwise, there he don't have any.
Can it be heard after lunch?
Can be.
Yes.
I do 70 also. 70.
70?
Yes. Well,
Yes,
that
yes.
is ready. The state. So final disposal matter. Any other.
Any other day.
Patient concern.
He says that you are ready, but I am not ready. That's what he says.
I am ready.
But he says that he is ready, you are not. Okay.
I
On request of the
Yeah,
state council.
interim order to continue.
Interim order to continue. 70. Okay. David, Joint David there. Yes. Yes. At the instance of opposite party number 2, FIR number 2, to be registered against the petitioner, allegation of the petitioner and so on so. After investigation, charge sheet has been filed in the present case. Subsequent thereto, by the order dated 16, by order dated 18/6/2020, the learned HDJMS bracket S prefecture has taken cognizance of the offences punishable under section 323, 427, 379, 506 IPC against the petitioner. Before the trial is commenced, the parties have entered into a settlement, and on the basis of settlement term, the present petition has been filed. The petitioner number 1 and opposite party number 2 are present in the court, being represented by their respective counsel identified by them. The parties have also filed a self-attested, parties have also filed a notary affidavit attested before the notary public clerk and placed as Annexure 3 to the petition inter alia, stating as under para 1 to 5. Para 1 to 5. The opposite party, who is opposite party? Prakash Chandra Mishra. The opposite party number 2 and the petitioner and opposite party number 2 both are practicing advocates. The opposite party number 2 who is present in the court on the query from the court states that due to misunderstanding and sudden provocation he has lost the affair. However, being a fellow brother of brother colleague of the petitioner in the bar, he has settled the dispute and doesn't want to proceed against the petitioner anymore. Anyway, on the counsel for the state submits that the allegation made by the opposite party against the petitioner in the FIR is very minor in nature. Since the parties have settled that issue and filed the affidavit before this court, there is no legal impediment in questioning the FIR regarding that to the mentioned. Dancing and so on. So it was yes. Was yes.
62.
Your Lordship, ma'am, on behalf of Mr. Dhara, there is no instruction from.
No instruction.
No.
The 162. The petitioners have filed the present petition seeking quashing of the quashing of Bantola PS case, Bantola PS case number 391 of 2023 on the ground of settlement. The matter was earlier listed on 27/8/2024. The petitioner brought time. When the matter was taken up on 7/10/2024, non-appeal for the petitioner. Again, on 19/12/2024, the petitioner requested for an adjournment. When the matter is taken up today, the land counsel for the petitioner submits that she has no instruction from her client regarding that to the aforementioned. The petition is dismissed. Yes.
59.
Yes.
Ore or 6 notification bele kon kisam thila magithile. The kisam was Bonamami.
Yes.
Highlighted the relevant portion.
There are two matters.
Yes. Dispose of leave.
Now, what is the case? Let me understand first.
What has happened? My father was, record of rights were there in the name of my father. There was a land, after his death, we sons got it. And there was a land acquisition proceeding sometime in the year 2004. 4-1 notification was there. And there compensation was granted to land acquisition officer issued us notice. We have appeared and shown the record of rights. Based on that, compensation was granted to us. Now the Vigilance Department comes forward and says that the land, after the notification, there was a change in the kisam of the land. That land was converted to be Ghorabari, that is homestead, and therefore we have taken more money. Because valuation will be different. On that basis, they have filed it. But my case is, there was no change at my instance, nor there is access for me. Whatever is the record of rights there with me, on that date, I have produced it. So my friend says that no, there was a change, and therefore your lordships directed that let the record of rights.
Where is the criminality?
Right. The thing is that the notification was made. At the time of notification, the sum of land was Bonamandi. So compensation was estimated and awarded. Subsequently, by adopting fraud, They changed the, they
What fraud? Because they're
fraud means,
Hmm.
I am telling you, fraud means they adopted fraud, manipulated the case records and prepared for the ROR and managed to obtain the compensation money at a higher
rate.
And your lordship kindly see the page 70. I have given the charge sheet copy relevant portion.
This one?
This one. Yes.
71
70.
70 of
Flag marking.
repetition, no?
Yes. Yes. Statement.
Lordship kindly next 70. Page 70.
Okay, 70. Okay. Yes, I got it.
ROR stands in the name of Venudhar, second part. Of Chudapalli of the Tahsil Balangir speaks that all the alleged plots so and so were Bonamamali Kisam. Subsequently, changes have been reflected regarding Kisam of the plots of Garavadi by encircling the respective plots with the signature of deed and Tahsildar Balangir by reflecting the reference of conversion case number 6/2008. But notification at the time of notification, there was no such change and it was Bonamamuli. That's the record.
Tahsildar is also an accused.
No. Subsequently, the Tahsildar signature is also false. And the conversion case number 122 of 2008 on verification found that is related to another case record of Mamata Mahanti and of other location, that is Lakrapalli. This land relates to Chudapalli. Everything has
all this manipulation is done by them.
This at the instance of the petitioners in connivance of the public servants.
Yes, sir.
Well, you kindly have a look at what my friend is producing. I have not seen. Let him serve a copy. I will find.
Page 70.
Page 70.
70.
You supply the copy. I think
you will also for a moment. You will also see page 20 of the petition. Annexure 3 series. There was a proceeding in the top line. It will be there.
Yes.
Sanskar 19C case mutabik. So in 2003 there was a proceeding partition 19C, and there on next page you will also see page 21.
Yes.
Just 4-5 lines above 1581 is the plot number. That is Gharabari. In 2000, this is one of the plots they say that I have manipulated. In 2003, in the record of rights, if it is there, how I have manipulated it after 2004? Notification has come in 2004. Anyhow, let him serve a copy of that. I will give it.
These things are part of the charge sheet. Either this is part of charge sheet.
No, I have produced the record of rights.
See, these things are again your defense.
No, I can understand. Let him produce that.
Again your defense.
Let him give the copy.
I don't think at this stage.
No,
Supply the copy.
Supply the copy. I will.
You must be having a copy. He is relying on the charge sheet.
Anyway, he is producing something. Let him give copy so that I will.
Now trial has commenced. Witness has prosecution.
But that has to be stayed. That is another matter. By saying that.
Tell, see the copy, but I don't think at this stage I can interfere.
Prima facie, I will show that there are so many documents.
The problem is the document which you are relying upon is not form part of the charge sheet.
That I will check up. What the point is, the only point involved is whether after 2004 the kisam was changed or before that. That's all the point.
No, whether the manipulation is done by you or not, that's the question. You encircle the numbers and
that's right.
Even the signature of the Tahsildar is manipulated. These are the allegations. I don't know. Maybe correct, may not be correct. But that has to be in the trial only that can be sorted out.
I can understand, my lord. What I am trying to submit is, if the public records show that even prior to 2004, there was no change, there is already change affected, and there is question of affecting change after 2004 would not arise.
But why have you manipulated then?
I have not manipulated. Question doesn't arise. I am a beneficiary. My father died and record of rights are there.
Show me.
Partition is there.
Show me that manipulated document. They say that you encircle, signed the signature of the Tahsildar. That is found to be manipulated.
So, all those things would arise if by 2004 the record stands otherwise. So let him give that.
This is
I understand.
Inference kind of thing, inference kind of thing. We'll see. Okay, supply the copy. Simply adjourn. Yes.
Let the interim order continue.
Interim order.
Okay, not to arrest.
Entry order is there.
Yes, yes, it's there.
No. Entry order is
6,
not there
11,
because ban is
2012.
going on because
6/11/2012. Why are you saying no? See the order.
subsequently.
No, it was at the stage of investigation.
Yes. Not to arrest.
As a military measure directed that the
That is being
petitioners are
concluded.
participating in the investigation as and when required and all.
That order has been concluding till 2000.
Main thing is that
Charge sheet has been filed now.
charge sheet file नहीं ସେଥିରେ କଣ ହେଇଛି charge sheet file ହେଇଛି ଆହୁରି ମଧ୍ୟ ଦିଟା କେସ୍ ସେ ଫାଇଲ କରିଛନ୍ତି. Your lordship has also passed order in another case to proceed on the trial. And that consequently.
I'll not say simply urgent. We'll see. I'll not get into all this. Yes.
74.
Yes. 74. Yes. Opposite party number 2 and 3 are already insured. However, none appeared for the opposite party. Yes. Allegation against the petitioner is that opposite party number 2 is informant clause report of measure the house of the petitioner elimination violation of the law on the yes, yes. Who is there? Nobody is there. None appears for the party. See the interest of justice adjourned. Interim order to continue. Yes.
25.
First, your lordship may kind of take up. Sawaitam, Nirmal Chandrapan, Pathan. Wife and husband, they have been entangled in this time.
So batch of cases judgment is pending. Departmental proceeding, criminal proceeding.
I have already filed, your lordship may kind of keep it as a judgment.
Same issue.
Same issue. And another thing, my lord, my friend is correct to that extent. Another thing, one thing is to be added in the instant case. Sub-item, your lordship has kept pending for judgment. That is, while the department proceeding, the marshalling officer is the IO.
Yes,
and
yes.
he has, that is the, in case of second item, Nirmal Chandra Pradhan. First item is wife. Both are in the last stage, my lord. I have nothing to show you because suffering from cancer within 1 or 2 months. First, my lord, he's the wife. Taking result of the 109 of IPC, they have entangled. My friend will be agree with my submission before your lordship. There is no material that I have abetted my husband to commit the crime. There is no conspiracy theory as per the 107 of the IPC.
First,
That is
first insofar as the second matter is concerned.
second matter, your lordship may keep that as a judgment.
Reserve. I'll write down. Second matter is there. Second, Nirmal Chandra Bala.
If the both the matters will be
okay.
I have already filed my argument note, additional affidavit, everything. Judgment.
Regarding dropping of criminal prosecution once the delinquent, once the petitioner is exonerated in departmental proceeding, is sub judice before this court. In the batch matter, the judgment has already been reserved. In view thereafter, the matter is the present matter, the argument in the present matter is heard and the judgment is reserved. Is a group matter no group matter. The group matter hard copy.
First matter touch one.
Hard copy 9 to 15.
My senior.
Batch matter.
But batch matter.
The batch matter 17 control.
Both the matters, my lord.
And
for judgment.
Second one, no. Second one, I'll hear it. Okay. First one, I'll hear it. Simply example. Right. Yes.
Interim order is there in first matter.
2867 applies the tag.
Judgment.
2867 the tag is you. Seta will hear it. Yes.
Seta usual.
Yes. Next 76.
In first item, your lordship may kindly continue interim order.
Yes, next.
76. 2866
last 7 years.
Interim order may kind oblige.
Money has been
76 is urgent, na?
Your lordship, I have not been informed.
I can't help it, sir, because if the lawyer comes and says
the difficulties it has been listed, may kindly be posted to.
This is very unfortunate, you know. The lawyer comes and mention in the morning, He doesn't inform the other side, then what can I do?
Date may be given, Your
Huh?
Lordship. Specific date may be given.
Date will be given, don't worry. Date
Next
will be
week, Your
given.
Lordship.
But you tell your friend who has mentioned it. This is the,
Inform.
minimum courtesy is you should inform the other side. You mentioned what?
At least stay is not in force. It may be vacated. At least stay.
How can I vacate it? The petitioner is taking time.
Your Lordship.
What do you want?
Yeah, the last order of the lower court.
I can't do anything because petitioner is not there. That's the problem. If you can call him, I'll pass it over. That much I can help you.
Next week, Your Lordship.
We'll see. Yes, urgent. Yes.
77.
On behalf of Mr. Das, let's say, they were short meeting notes and already had the matter.
No, it has to be heard. I don't know.
Sir.
Only issue
Sir.
has the deposit, fixed deposit made by the. in the-
I don't want to reserve more judgment. I
No,
feel.
no, କିଛି ନାହିଁ, ଏଇଟା it can be.
You give 2 page, 3 page note and I'm accumulating unnecessary. When I read the page is altogether different from the written submission.
Your Lordship kindly see.
Written submission is going in one direction, the petition is in another direction.
ଏଥିରେ ଖାଲି ଦିଟା କଥା ଥିଲା ପୁଅ ଆଉ ଝିଅଙ୍କର ଆକାଉଣ୍ଟରେ ଡିପୋଜିଟ ଅଛି ଫିକ୍ସ ଡିପୋଜିଟ ସେଟା କିଏ କରିଛି ବୋଲି if the documentary evidence collected from the bank shows that has been made by the mother of the petitioner mother and petitioners in the name of the son and daughter.
What are you seeking here? Quashing?
Quashing of the criminal proceeding initiated at the instance of the locality.
So yes, I understand these their cases they got stipend and all. Stipend is exhausted and thereafter money is being deposited. That I know.
ପୁଅର stipend ସେତେବେଳେ ପାଇନଥିଲା କାରଣ MBBS କରୁଥିଲା ଝିଅ ସେତେବେଳକୁ ବାହା ହେଇ ପଳେଇଥିଲା and is residing at a different place ଆଉ account ବାଲେଶ୍ୱରରେ account ଥିଲା ସେମାନେ ଜବଲପୁରରେ ରହୁଥିଲେ MP ରେ ତେଣୁ ଡିପୋଜିଟ କ୍ୟାଶ ଡିପୋଜିଟ ହେଇଛି ମଦର ଡିପୋଜିଟ ନିଜେ କରିଛନ୍ତି ମଦର ଆଣ୍ଡ ଫାଦର.
If that is the kind of evidence, how can I quash it at this stage?
Documentary evidence and they have also stated categorically stated in their statement.
That's the problem. What do you say in your written submissions?
Postgraduate.
Postgraduate period because postgraduate period ରେ deposit ହେଇ ନାହିଁ.
Postgraduate ର ନେଇ नांती केमती से तो पाइचंती stipend सेही period रे.
Arey bhai, why mother has deposited everything in your account and all these things I can't decide at this stage. If you want, I will have to write a judgment. It will prejudice your trial. I can't go into every account and say that yes, this is deposited and this is not deposited. See, vouchers are being filed. Signature of your mother contains in those vouchers. Cash is deposited in your account. What else you need for sustaining a charge sheet?
ସେ ନିଜେ ବି ହାତରେ ଲେଖିକି ଦେଇଛନ୍ତି ଇନଭେଷ୍ଟିଗେସନ ବେଳେ both the petitioner ଯେ ଆମ ପୁଅ ଝିଅଙ୍କର ୟାକୁ ଏଥିରେ ଯୋଡନ୍ତୁ ନାହିଁ ଆମେ ଏଗୁଡ଼ା କରିଛୁ. And documentary evidence is corroborated, also corroborated.
So that's the whole difficulty. I had issued notice because I had sympathy for this young.
ସେ ଦେଖିବା ପାଇଁ ଯେ ପ୍ରକୃତ ଡିପୋଜିଟ ଟା କିଏ କରିଛି.
But if you want me to write, then I'll have to write all this. That's the problem. Think over.
If it's not me, that's may
Because if I deal with all these things, I'll have to write something. Then it may prejudice you. That's the worry. Think over it. I'm just adjourning it. If you want, I can very well deal with it because the voucher and everything is being produced and your signature, your mother's signature is appearing there.
if your
It keep it.
mother.
See.
78.
Wait, please, my lord. I'm appearing virtually, my lords, on behalf of the petitioners.
Yes.
My lords, on the last occasion, the opposite party number 2 had appeared and had sought time to file a reply, my lords.
Today nobody is there.
My lords.
None appears for opposite party number 2. In the interest of justice, last opportunity granted for filing counter. these the matter of interim order to continue. Yes.
Deeply obliged, my lords.
79. May I please, your lordship, here the milord, the petitioners are milord husband and father-in-law, mother-in-law. His prayer is made to quash the charge sheet as the proceeding, where the 498
What
case
happened to mediation?
failed. Mediation failed about the quantum part that was not decided due to some quantum was not to match as per the.
How much she demanded?
They are 30 lakhs. They went to 15 lakhs. My client went to up to 15 lakhs. They asked for
30 lakhs.
30 lakhs.
Mediation report doesn't mention.
No.
But
I'm saying.
roughly,
And,
how much you can increase?
I'll take instruction. If 15 lakhs more.
498 case.
Yes,
Or
right.
what will you get out of it?
FIR
Yes.
is under challenge.
Huh?
FIR is under challenge.
No, better. I have also
But
annexed the
see,
charge sheet.
Ultimately, they can't stay together. They have to be separated. It is now in
He has
Yes.
already filed a CP.
money matter.
Right, right,
Eventually,
yes.
money matter.
Yes.
Money matter. You demanded 30. He is saying 15. You increase little bit, you decrease little bit, and
Yes,
finish it up.
up to I went to 15. 13, I went to 10 because the petitioner is working as about the.
Leave 25.
Yes.
I'll record it and finish it up. See, you must understand one
Yes,
thing.
yes, ma'am.
She is a girl. It is very easy for you to get out of this relationship and you get into. But there is a
You
taboo
will
attached
may
to
keep
the
it
girl.
to next week. I will take instruction. I will.
Isn't it?
If my senior will
What do you
take
say?
instruction for his client, if something can be enhanced.
You must take. I'm just giving you.
My lord is proposing, I will take instruction.
I'm not imposing it.
No.
See, since you have asked for 30, he's saying 15.
I have no instruction.
That's what he says in mediation. That might be the figure. Maybe I don't know. If you are asking much more, then I
Much
can't.
more is
agree.
not. Because he's
If it
working
is
as a-
30, 15 in between,
My lord.
then 25 is an ideal
But
figure.
25 will be, but 20 I can up to drag them to up to 18,
No, no.
20.
What are you doing, by the way?
My lord, librarian in Acharya Harrier Institute of Cancer.
No librarian
Yes.
will engage you.
No, my lord, librarian is. Yes.
No librarian will engage you.
But he's a librarian and he hails from my place, nursing. But his father is staying in Jaipur, Koraput. They're settled there.
Anyway,
preacher.
I think 25 will be ideal, but I don't know whether he
No.
demanded 30 or what. If she might have demanded more, I don't know.
I'll take instruction with
I'll
regard
just
to.
put it. I'll just put
come
it
back,
for
Lord.
coming week. Just seek instruction.
I'll take instruction.
And there is now divorce proceeding is going on.
My lord,
There
I
also
filed-
you have to pay alimony.
Yes, I filed a conjugal rate, super conjugal rights. Then filed because it could have materialist.
You can't be reunited.
There's
You can't be reunited. This is only money matter now.
yes, that was.
Money matter. Okay.
And it was well, my associate was there. They were all together, almost it was going to settle. Suddenly it came to the and it could not materialize.
Anyway,
My client was agree some extent because they wanted to.
Next week.
They should kindly extend the interim order.
21 বাটে করে 21 নেই তারপরটা করি হ্যাঁ 26 27 করে 26 27 করে ইন্টারিম অর্ডার কন্টিনিউ
After election, first week, election is there. So, election is there. So after first week.
First week. First.
You will kindly interim order to extend.
Yes.
Publish.
80.
My lord, you also kindly remember, each and every occasion, the opposite party has filed her appearance through her advocate, but they're not coming to the court. The last occasion, my lords made query why you are not giving enhancement maintenance. My submission was, sir, all along I am ready to take back my son and wife, but they are not cooperating. They are not coming. So moto she has deserted. Even if I have given option in my service place or in my village, wherever you like, you come. But they are not coming.
What is the order, impleadment order system?
Impleadment order, my lord, earlier, the interim maintenance, the maintenance was 2,500, 1,500 and 1,000. It has been enhanced to 6,000 and 4,500, total 10,500.
Earlier, what was the...
Earlier, all total 2,500. Now it has been enhanced to 10,500. 6,000 plus 4,500. I am ready, but I am ready
6,000 for the wife.
6 wife and 4,500 to son. But I am all along ready to take back my children. Your Lordship, during the course of cross-examination, the wife has categorically stated, I have so much deserted. No torture, nothing.
What are you doing?
I am serving in border security force.
Border security force?
Yes.
10,000 rupees is very...
Sir, ମୁଁ ଦେବାକୁ ରାଜି ମୁଁ କହୁଛି ମୁଁ ନେଇଯିବି ସେଥିପାଇଁ when the matter was admitted my lords yes let them appear thereafter I'll send it to the mediation.
If they don't appear, what to do now?
Then your lordship will hear this or ନହେଲେ interim जो order ଟା ହେଇଛି ସେଟା stay.
I don't want to reduce this to 10,000.
ନାଇଁ sir ମୁଁ କହୁଛି ମୁଁ ନେଇଯିବି.
That is a different story altogether.
Yes sir. ସେ ଆସିଲେ mediation को
She's not coming forward. What to do now?
But they have file power.
Who is the lawyer?
Mr. Tripathi. Yes, Rudamdo Tripathi.
Then I'll notify now.
ମୁଁ ଚାହୁଁଛି sir settle ହେଇଯିବ ମୋ ପିଲା ଛୁଆ ନେଇ ଯଦି ଆସିବେ mediation କୁ if my lords will send then
why don't you call him?
Sir ମୁଁ ଦିଥର ଦେଖାହେଲାଣି criminal ବାରେ ମୁଁ କହିଛି.
It's a very catch-22 situation. I can't do anything. I don't want to stay. For 10,000 is very difficult to stay.
But your lordship knows.
You suggest me what to do now.
No, your lordship knows law is very much clear. If the wife has deserted so much, then she is not entitled to get maintenance.
Maybe, but it is you are a border security force officer.
And
And 10,000 rupees is only the amount, and it's very minor. And that also you need interference. I don't need.
Sir, only my intention.
And children are admittedly with her.
My only intention, if they will appear, then my lords will send to mediation.
What I'll do is I'll send to mediation. Let the coordinator make an effort.
Right on. Notice
despite the notice was issued to opposite party, Mr. Mugang Mahapatra entered appearance. However, since last two occasions, none has appeared for the opposite party. On 12/2/2025, a peremptory order was also passed. Even then, none appeared for the opposite party. This is a dispute arising out of interim maintenance order. Therefore, and then counsel for the petitioner submits that he is ready and willing to take back the children with him, and also ready to take the responsibility of the education of the child, education of the child. Regarding head to the nature of dispute, I'm inclined to refer the matter to the mediation. High Court Mediation Center. Coordinator has to issue notice to the opposite party first by fixing a date for exploration of the mediation out of court settlement. File a report before this. Awaiting mediation report, release the matter.
81.
Yes.
On last occasion, your lordship directed me to file certified copy of the 204 for witness examination, examined, and regarding the civil suits pending or not. Here, your lordship, and further, my lord also directed me to take instruction regarding the compromise with both the party. Here, your lordship, the case was initiated by me, and that was registered as GR case. And the same cause of action, after lapse of 2 months, there is another once issue was filed before the court, and the court was taken the cognizance. Here, your lordship, there is no chance of any compromise, your lordship, because there is a case with a counter case, your lordship, without any reason. With all the family members are involved in the case. Now I am
My lord, on behalf of Mr. Sitikant Mishra, I pray for next week. He will be appearing in this matter. I pray any day next week.
See, the allegations are very, very minor.
My lords.
Cross case is there. Why don't you settle the dispute? For the small dispute you are dragging.
My
That's the reason I gave intelligence.
My lords, I will take instruction.
Right. On behalf of opposite party, an adjournment is sought. Adjourn the matter to so and so. The interim order passed earlier shall continue till next date.
My lord, I am serving the copy.
What is that?
Regarding the copy of the 204.
The additional document,
And
Mr.
the-
Ponda, learned counsel for the petitioner is filing some additional document by giving advance copy to the counsel for the opposite party. Yes, file it in the counsel.
Next, court copy ta
Entry
file
mode,
in-
entry mode. Yes.
entry mode to be continued.
Continue. Yes.
82.
As agreed by both the parties, my lord. The lordship may send it to the mediation, High Court Mediation
Right
Center.
on.
We'll try our
The-
level best to
yes,
settle.
yes.
Only prayer.
Parties appearing, the councils appearing for the parties conjointly prayed that the matter is likely to be settled out of court if it is sent to mediation. Mediation, regarding to the submission made by the parties, refer it to the mediation center, so awaiting mediation report. Listen.
Sir, the lordship may say, along with the petitioner, the husband of the OP number 2 also appear in the.
And the mediator, sorry, the coordinator of the mediation center shall issue notice to all stakeholders. All stakeholders and explore the possibility of settlement. Okay. Entry mode to continue. Entry mode to continue.
Entry mode to continue.
Entry mode to continue.
Great.
83.
Sir, in fact, state has filed. We obtained instruction from it.
But in view of the state's affidavit, I think that nothing remains, survives in this case. State has clearly said by affidavit that the petitioner has no involvement in this matter.
Is it so? This is what Instruction Advocate General's Office.
Lord, para 7 of their affidavit.
That B, I think.
Huh? They have no kind, there is no involvement of any kind. That's what. That's it. Hence, no criminal liability lies.
It's like this one. In one sentence, I must give your lordship will dictate the
Hmm.
52(1), Roman 1, 62 of the excise.
52 and 62.
Roman 1,
52A,
Roman 1,
Roman 1.
and 62
Hmm.
of Odisha Excise Act.
Yes.
Odisha Excise Act.
Why there are many petitions?
Yeah, I'm saying.
Hmm.
Not 2-3 licensees.
Acha, Ramesh Soni and Sibo Prasad Padi.
Yes,
Yes.
licensee.
Yes.
Repeatedly licensed.
Mhm.
They procured this liquor from the Beverage Corporation Depot. License is valid. Permit issue. Gate pass issue. Valid gate pass. By the time this year was drawn, gate pass was valid. All that happened is while driving up carrying the material from the warehouse, but that
He was apprehended.
in the night period.
Hmm.
He stopped the vehicle at a place in secured place so that next day morning validity is there. Next day morning he will deliver it for the license. Since the election process was going on, these people,
I understand. Okay, then different affairs.
one position.
Police report is one in both the matters. Okay. And then I'll have to pass separate orders then.
I think one case is there.
Two, Sibo Prasad and Soni.
Two cases.
Sibo Prasad, Soni, both.
Same order, common order can be passed.
Common order first, right on. Petitioners are accused in what is that case? Accused in relation to PR case. What is that PR case? What is it?
2ACC case.
Huh? 2ACC case.
Yes, 2ACC case number 460 of 2024.
24. Huh? For release commission of offence punishable under section 52A1 and 62 of Orissa Excise Act. The allegation against the petitioners are shown. The notice was issued to the statewide order dated 20. The matter was taken up on 21/8/2024, and this court passed the following order. The order. Pursuant thereto, the Persons thereto. Have you filed the counter affidavit? An affidavit also you filed. Persons thereto, the investigating officer has filed an affidavit dated 11/9/2024 inter alia stating as under. Which are the paragraph?
Para 7.
Para 7. 4 and 7. 4 and 7. 4, 5 and 7. Or 4, 5 and 7. And 4, 5 and 7. Mr. Vishwal appearing for the state has also submitted the instruction received from the Inspector of Excise, EI and EB, Unit 2, bracket ND, Sambalpur, which the relevant, which reads as under. Mr. Mr. Ratho, senior counsel, appearing for the petitioners, submits that in view of the counter affidavit and the instruction so received from the inspector of excise, no case is made out against the petitioner. Therefore, continuation of the 2CCC case against the petitioner, he would be futile exercise. Regarding head to the stand taken by the prosecution and the report submitted by the investigating officer, the submission made by Mr. Ratho deserves merit. Accordingly, taking into consideration the aforementioned circumstances, I am of the considered view that the case of the present petition is squarely covered by the judgment of the Supreme Court in Gyan so and so. Hence, subjecting the petitioner to the rigors of the trial, I destined to be a futile exercise. Hence, the so 2CC case, the petitioners are quashed. Yes. Yes. Same common order passed. Common order passed. Quad the petitioners. Likido, quad the petitioner, Ramesh Soni and Sibo Prasad party is quashed.
84.
It's a compromise case. Last occasion, the lordship directed to appear with the petitioner available in formal. Accordingly, they have taken the
Settle this food.
Yes.
What are the allegations?
Recently, the petitioner wrongfully restrained the informant and outraged or molested. Here, petitioner wrongfully restrained the informant as well as the outraged or molested. Offensive 354A, madam. Only going to outstanding civil dispute, then informant lost the false report. Subsequently, she realized her mistake. She already married to another person.
Okay.
Here the petitioner.
At the instance of opposite party number two, FIR number 2 came to the register against the petitioner, and the allegation against the petitioner, second paragraph, allegation against the petitioner, so and so. After investigation, charge sheet filed?
No. Stage of
the investigation is going on in the present stage. At this stage, the parties have entered into settlement. And the consequence, the petitioner submits that there is a long-standing civil dispute pending between the family of both the parties. The incident has arisen out of the dispute, out of this civil dispute. The parties have settled their dispute. They have filed the affidavit also.
By number 2. Affidavit filed by the informant.
Where is that? The opposite party number 2, the informant, has filed an affidavit dated 29/6/2024, inter alia stating as under para 2-3 to 11 to part 2 to 11. The petitioner and opposite party are present in the court. They are being represented by their respective counsel, identified by them. They have also filed self-attested copies of their Aadhaar card to establish their identity, which are taken on record. The opposite party number 2, who is present in the court, on the query from the court submits that due to a misunderstanding and sudden provocation, she had lost the FIR. However, on the intervention of the well-wisher and village gentry, they have settled the dispute. She doesn't want to end. She doesn't want to prosecute the petitioner anymore. Mrs. Maharana appear for the state submits that the dispute is inter se party. They have settled their dispute. Admittedly, there was civil dispute pending between the parties. Pending a civil dispute in the between the families of both the parties are pending. Therefore, there is no legal impediment in quashing the FIR. Regarding it to the aforementioned, quash the FIR. You pay 5,000 subject to petitioner paying a cost of rupees 5,000 to the informant. This is also quash. 5,000 is
added to another question, not
5,000 she has come to the court. If you say I'll increase it now, pay 5,000. The poor lady has come. Yes. 5,000 tak koi nahi. Yes. 5,000 taka diyo receipt do.
Subject to
Lordship, item 85, I'm appearing on BC, Your Lordship.
Yes.
For the petitioner, I'm seeking an adjournment for at least a week, Your Lordship.
Adjourn on this case. 86.
86.
Huh? Non-appeals for the parties in the interest of justice. Adjourn me. Yes.
87.
May it please, Your Lordship. May it please, Your Lordship. Your Lordship, may kindly have a glance to page number annexed 2 series. Starts from page number 87. My Lord.
Page?
2 series, Your Lordship. Starts from page number 18.
What is your case?
My Lord, here, my Lord, the present petitioner assailing the proceeding. The offense is 420, 467, 468, 294, 120B, this offense. I purchased the land from the complainant.
Where is the opposite party?
Opposite party, my Lord, notice already served.
Just see, service.
Yes, Your Lordship. The opposite party counsel is already appeared. He already filed counter. I also filed rejoinder. Everything is there. The matter is preponed to 10th March for hearing, my Lord.
10th March.
Yes, today, my Lord.
But nobody is there.
Nobody is there. Previous date also is not appearing. There are what happened in this point, my Lord?
Anyway, in his absence, I can 420 and all is there. He has to be there. Right.
My Lord,
despite notice and the none appears for the respondent opposite party. Yeah? Oh, sorry, opposite party number 2. Although the opposite party has filed the counter, but since last 2 hearing, none has appeared on his behalf. In the interest of justice, last opportunity is granted to the petitioner. So, in the meantime, petitioner is also granted liberty to move application before the trial court seeking an adjournment owing to the fact that the matter is subject to. He is not coming. What to do?
Yes, purely civil dispute, my Lord. I purchased land because today the land value is hyped, my Lord.
Okay,
that's why he is claiming.
I am just. Yes.
88.
May it please, my lord. I'm appearing virtually, my lords, on behalf of the petitioner.
I am on behalf of N. Parija, my lord. This matter may be taken up.
Okay. On behalf of Mr. N.P. Parija, land counsel for the opposite party, an adjournment is sought. Adjourned to so interim or to continue. Yes.
Deeply abridged.
Last occasion, my Lord, instruction is used. Instruction. Paragraph 3 and 7.
What is this case?
My Lord, case is on the ground of compromise, my Lord. Your Lordship has directed the learned State Council take instruction whether the petitioners are defrauded other victims or not. 3 and 7. Whether the petitioners are defrauded other persons or not.
Yes.
No, other person not there. Paragraph 3 and 7 is relevant.
3 and 7. But the statement of without accused obtained by the SBI the payment of cash to the accused person.
No antecedent also.
Yes, the letter is from the bank account statement of the accused and from the testimony. The routine of the retention and so on. Seven, huh?
Seven.
The claim advanced by the petitioner that the matter has been settled by way of compromise is not affected as the victim Dina Morana and never disclosed about such settlement at any point during the use and there is no such document compliant. Where are the parties?
Parties will since we got several dates have been adjourned in the meantime.
Because,
that is
in the para 7, it says that the claim advanced by the petitioner that the matter has been settled by way of compromise is not a fact.
Both of them will
Not a fact. That's what he says.
The IO said.
Yes.
Both of them are appeared if your lordship on the last occasion of
No, but he says that
yes,
it was not disclosed at the time of investigation.
My lord.
Yes. Yes, Lord.
Bring them.
Yes, on the 30th of January, my lord, your lordship had both of them are lordship. Your lordship kindly fix a date, my lord, so that she can appear. Also, on the last occasion, your lordship had directed the
2nd April. 2nd April.
on the last occasion, your lordship also directed the victim, my lord, to appear through BC, my lord.
Let them be. Anybody can appear through BC. BC is a permissible mode, no problem. Even if she appears in the BC, then you have to identify. That's all.
Yes.
That's the only idea.
No, they are.
Therefore, I just generally write he appears and you identify him. As simple as that.
Your lordship kindly fix a date.
Date, second. Yes.
90.
My lord.
Temperance of adjournment.
The request. कहाँ पे पढ़ मांगते हाँ
Petitioner.
petitioner पे ना respondent.
Petitioner.
Okay, on behalf of petitioner, adjourn.
91.
Mr. Your presence is the objection.
Rightly,
Isn't it?
rightly, my lord.
Your projection,
Yes.
mere presence is enough.
It's quite enough. And filing objection is formality only.
Mr. Kotikal, in counsel for the opposite party, seeks an adjournment to file counter to the petition. 2 weeks time, 3 weeks time.
No, my lord, fact remains, my lord, that interim order is there. But fact remains, my lord, my selection is selection for the higher post is going on. Now in view, I say,
Because he may get some benefit, that's the idea.
no,
2 weeks after. যদি quash level, may get some benefit.
but fact remains, my lords, what is happening? My lords have passed the cognizance, there is no problem.
Is there any chance of settlement? No.
No, it's a good thing.
କୋର୍ଟରେ ଯାଇପାରିବ ତ ଚାର୍ଜ ଷ୍ଟେଜରେ କରିବେ ମୁଁ ତ କରିବିନି ନା I am not going to do it.
ନା ଗୋଟେ ଯୋଡେ କଣ ରହିବ ମୁଁ ତ କହିବା କଥା ମୋଟାମୋଟି
Why don't you settle small
ଏଠି ସେଟଲ କଣ ସେ କହୁଛନ୍ତି ପୁରା ଯେହେତୁ ଆମେ ଅଫିସର୍ସ ଆମେ ଯାଇଛୁ ଭାଙ୍ଗିବା ପାଇଁ ଡିମୋଲିସନ କଲୁ ତାଙ୍କୁ ଭିଡାଭିଡି କଲୁ 354 and that thereafter all
ପଇସା ଦରକାର କ୍ଲାଏଣ୍ଟ କୁ
ଆରେ ଯେତେ ଯାହା ଦେର କଣ ତ
Protest petition.
take some money and
Against protest petition.
their services at stake. That is why they are otherwise
fact remains I have not gone there, but fact remains the allegation is that I have gone there in official capacity. In official capacity, I will.
No, what I am exploring a possibility that can I send it to mediation? That's what I am saying. Nothing. Okay. If otherwise, I'll send it to mediation and finish it up. Possible, they will pay some privately. They pay something.
Payment କଥା ଟିକେ ତାଙ୍କ ମୁହଁକୁ issue ନୁହଁ. Issue ହଉଛି ଯୋଉ ଜାଗାଟା ବିଡିଓ
you be wiser to pay something and finish it up. Otherwise, in the technicality, you keep on fighting, then you are in trouble.
So
Wiser thing would be that.
Let him take instruction, but I want to may submit one thing.
I am not saying that you on record you pay.
No.
Otherwise, you pay. That's what I am saying. Recording may not pay.
On record. Question is not that. Question is
Protest petition.
I am. चलो
in due discharge of
liaison करो देखते
interim order.
But still you just sit with him and find out. Because it's,
my learned
it's
friend
good
is
for
there.
your client.
No,
It's good for your client.
my learned friend is there.
Because now Mr. Kottagi has come, he has a larger view of all these things and he can very well.
I think we may not be under your control. I know that. I know that. Those who are behind the screen, they are all the detached employed from media.
Then they are known to each other.
No, very much because I was
Just try it out. If possible, you do it, otherwise you will.
let him. But fact remains, my lords, in this case, the officers are unnecessarily booked on tax while discharging the official duty. And in the process, my lords, the no demolition, no eviction can be taken up. Everybody will come forward and I make an allegation like
I
this.
know that's that. Will
And
that
that
be-
too, here in
will
this
that-
case, here in this case, first the fellow reporter submits that final form treating the apparent false submitted. Thereafter, protest petition registered as a complaint case, and then cognizance taken.
We'll see.
Okay.
92.
May it please, my lord, I'm appearing virtually, my lords, on behalf of the petitioner. On the last occasion, my lords, notice was issued to the opposite party number 2.
Your service is
We are
ready.
Matrimonial.
Matrimonial.
Cognizance has been taken, my lord. They have challenged the cognizance. The petitioners are.
Cognizance for what offenses?
490 day 506 406.
I'll send it to mediation. Right. Okay. The dispute is arising out of matrimonial discord. Notice was issued to the petitioners, opposite party. For opinion of opposite party. Opposite party. Since the dispute is a matrimonial dispute, the matter to High Court Mediation. High Court Mediation Center. You can very clear.
All the parties are from the opposite party as well as the petition. Petition for mediation center.
My lords, I pray in the meanwhile, the proceedings before the learned court below may be stayed, my lords.
In the meantime, petitioner should move an application before the trial court, informing the trial court that the matter has been referred to arbitration. Mediation, and seek an adjournment. Yes.
Deeply appreciated. And I may be permitted, petitioner number 1, the husband, he is serving outside of Odisha, my lords. He may be permitted to
You,
appear.
you request the mediator, he will do it. What is it? Yes.
Deeply appreciated.
Anyone is ready?
Leonard Senior is on his legs, so lots of one password. Only one password.
Password means next day only.
Side is also not present.
You start. Somebody should start.
One password, Lordship.
Password means I will have to rise. Once rise, then I will not come. You start. Somebody has to start. Call the matters.
93.
Tell me, give me the what is the case, at least you give me the facts. Yes. Yes.
93.
Yes.
94.
My lords, in 94, I'm appearing on behalf of Mr. Satyasmuti Mohanty. My lords, he's in legs in another court. So, my lords, either may pass over or matter may fix a date. This is for final hearing, my lords.
See, these are the matters pending. See, when 2006 matters.
Yes, my lords.
And you
may
get
fix
an
it tomorrow
see,
also, my
it's
lords.
very difficult to get the time. You got the time, you don't want to do it.
My lords, he's actually in his
When I
legs.
can't do, then people will come and mention. That's the whole difficulty.
My lords, I'm extremely sorry for this inconvenience, my lords.
Now it's not my inconvenience.
It's my
It's the
inconvenience.
court time. Once it is urgent, then it will go to, I don't know. Yes.
My lords, may fix a date, my lords. As your lordship please. My lords, may
No,
keep
I'll
it
not
to
fix
tomorrow
it.
also.
I'll not fix it. If you are not ready, the matter comes, then I have other things to attend. I can't do like this. Yes.
87.
97, my lord. I'll have to pray for an adjournment. I'm praying for an adjournment.
Let's see, same thing. 2013 matter. Nobody comes. Then shall I tell that no appeal should be listed in this court? I am adjusting the time and try to do some appeal matters. And if people are not encashing the situation. And in the morning you will come and mention. Take up that matter. When I am taking up the matter, nobody is there. Yes. Which one?
His matter, his junior was seeking an adjournment. The matter that was called prior to this one. I'm sorry, madam. 94. I'm sorry. I apologize. 94 and there.
You are for?
Well, I'm for the appellant.
What is your case? Just 94. Let us see. Let us understand. If it is a big matter, then I can accommodate. What is this matter is about?
Well, it's a case where we have already been.
Yes.
I've given a hot notice solution.
See, in case I have time, I can hear it. Otherwise, never reach. In your lifetime, it will not reach.
No,
I tell you.
that is why we keep running, my lord. I'll have to finish it.
So at least you tell me the facts so that I will keep it reported and I'll hear the other side and finish it up. Get encash this opportunity of getting time. Yes.
Completely pardon,
Yes.
I'm so sorry, my lord.
Let me get the overall view and I'll keep it reported and I'll see the other side. I'll
Completely
see.
pardon.
Yes.
My lord, here is a case, my lord.
Yes.
Where it's the appellant here. So, my lord, may kindly see, he was. My lord, I've given a brief chronology of event. My lord, may kindly see this.
Yes.
My lord, here is a question of a work was done. Now the allegation towards me is I took some money.
Yes.
Under Prevention of Corruption Act, my lord. I took some money to give them the check measurement that I had done.
Yes.
Am I correct, my lord?
Yes, I understood it.
Now, my lord, here, what is relevant, sir?
Just do one thing.
Yes.
Just run through the.
Yes, ma'am.
So that I'll get an overall.
Absolutely, ma'am. I
Yes.
completely pardon.
Yes.
My lord, here on 25/6/1994, check measurement has been completed as per the evidence of PW8, who was the BDO Patrapada at the relevant time.
Yes.
16/10/1994, Secretary PW6, Secretary of the Gram Panchayat, joined the office of Gram Panchayat Burtala as per the deposition of PW6.
Yes.
11/9/1995, accused was transferred and relieved from Patrapada block to Chhatrapur block by office order number 1801 as per evidence of DW1. 19/9/1995, accused handed over charge of the seat as per the deposition of DW1. 26/11/1995, complainant and his wife approached the accused where the accused allegedly demanded bribe. 10/12/1995 at 2 p.m., informant Ghana Nayak lodged a written report before the SP Vigilance. Then at 4 p.m. on the same day, my lord, official witnesses present in the Vigilance office.
Trap case.
My lord. And then trap was laid, my lord, proceeded to the residence of accused appellant.
Yes.
Now, my lord, what is important also, I've got judgments. My lord, may kindly note on the same day, 10/12/2020, 10/12/1995, at 2 p.m., Ghana Nayak gives a written report.
Yes.
Now, my lord, within 2 hours, official witnesses has come.
And 45 minutes thereafter, trap takes.
After trap has been laid. So, my lord, there are also judgments, my lord, I'll place to your lordship. Although there is no set timing, but it says what are the procedures need to be done. You need to bring the official witnesses. You need to tell them what is it about. You need to also educate them that what are you going to do? How is it going to be done? All these solutions have to be shown to them as to how solutions will turn. Now, my lord, here within 2 hours, everything is done.
We'll see what trap preparation,
Absolutely.
evidence has come.
I could pardon.
Yes.
Now, 19/5/2020, Learned Special Judge Vigilance, Barampur Ganjam passed a judgment convicting the accused appellant in TR case number this arising out of GR.
Okay.
Now, my lord, what is my case?
Appellant's case here.
The accused appellant has taken the plea of complete denial. According to him, he had been transferred from Patrapur block to Chhatrapur block by the time of detection. By the time you asked me, I was already transferred.
Yes.
He had handed over charge of his seat on 19/9/1995. He had handed over the measurement books and bills.
The accused further took the plea that he had given 3,000 rupees to the contractor and his wife, my lord, who had approached me, the original complainant.
Yes.
Accused further took the plea that he had given 3,000 rupees to the contractor who had taken that work, and the said amount could not be realized, for which he did not sign the bill.
Okay.
My lord, what is it?
That was your defense.
My lord, that was my defense. Now, my lord, the trial court, after considering the case, was of opinion that the prosecution has established beyond all reasonable doubt that the accused, being a public servant, accepted the bribe money for showing favor to the informant in handing over the measurement book. The learned special judge Vigilance Barampur convicted the accused and sentenced him to undergo RI of 2 years and to pay a fine of rupees 3,000 in default of RI for 3 months.
Yes.
Read with this. Now, my lord, what were the issues that we had raised? First is no reason for demand of bribe. So there was no opportunity for me to.
There was no occasion for you to, accept or
completely
demand. Yes.
There, my lord. Now, my lord, we have said that there is glaring inconsistency as to the reason for demand of bribe by the present appellant. Complainant PW5 has alleged in the FIR and during its chief that the accused neither completed the measurement nor prepared the bills. On being requested, he demanded rupees 2,500 as bribe and stated that unless it is paid, he shall not record the measurement in the measurement book and shall not prepare the bills.
Yes.
However, Srimati Lalita Bodamundi, wife of the complainant PW6, who is the secretary, Baratala GP, has stated in para 2 of her chief that accused J did not measure the work.
The demand alleged to have been made on which day?
My lord, the demand has been alleged to have been made, my lord, on 26/11/1995.
26/11. By that time, you have already been transferred.
And have given charge, my lord.
Charge.
Both.
Patrapur to that.
Patrapur to Chhatrapur block.
That has happened in
1909.
1909.
Yes, your lord.
So therefore, on 26 there was no occasion.
No occasion.
That's why basically.
I
Yes.
completely bought it.
Yes.
Now, my lord, what does the wife of the complainant say? She says in her chief that the accused J did not measure the work and kept measurement book with him. In the meantime, audit party was to arrive for audit of accounts of our GP. So I went to the accused J and requested him to hand over the measurement book, but the accused J refused to hand over the measurement book, saying that unless the case of rupees 5,000 is paid to him, he would not hand over the measurement book.
Hence,
Hence,
that is the wife of the
complainant.
Yes.
Hence, as per PW5, the demand was made so as to prepare bills. Whereas, as per PW6, the accused demanded money to return the measurement book.
That's the major difference.
This is the first
Major.
discrepancy.
Yes.
One is they are saying that I did not
For
measure.
bill and the wife says that no, for returning the
give back the measurement book. Correct.
That's
I
it.
completely lost.
Yes.
Now, my lord, we have given the judgments as well, my lord. The next paragraph, my lord. To prove that demand for illegal gratification would be fatal and mere recovery of money. My lord, these judgments says that there has to be a reason. If you have not proven the demand, then mere receiving of money would not be there.
Mr. Rijbi, everybody is missing you.
Yeah, I'm so sorry, my lord. I apologize for that.
You are there, na?
Yes, I was there in the next court, my lord.
In this matter?
Yes, I am there in this matter, my lord.
See, couple of matter we can appeal. Otherwise, the appeal will never reach in the entire, for another 20, 30 years, it will not reach. So that's what I was telling him that at least you argue your part.
Yes, ma'am.
And I'll give you an opportunity. I'll keep it in a part head. And then we'll conclude.
I'm so grateful.
Well, the second ground of our defense is, my lord.
Please give a written note to him.
Well,
please give him so that should not go blank. Yes.
No, my lord, this
just note down, don't
my lord, sorry.
Stress out, he is making out his case.
My lord.
Then again, yes.
So great.
Well, the second ground was, my lord, anyways, my lord, there is a two discrepancy whether there was a point of measurement and whether we are only giving the measurement book.
Whether it's the bill or the measurement book.
That
is the two. The wife of the complainant says something and the complainant says something. This is first ground. Second ground is you have been transferred from Patrapur to somewhere else on 19th and the demand alleged to have been made on 26th. These are the two very
The third
specific
ground
things.
is, what about the measurement? The measurement itself, that they are, my lord, the first.
You please take seat. Please take seat.
Yes, the first ground itself was, my lord, the complainant said that I asked money to do the measurement and give the bills. To that, my lord, my reply is, complainant
That is the second issue. you are
Yes, madam.
yeah.
Complainant has stated that the accused demanded bribe to make measurements for the preparation of the bills. This is absolutely untrue in light of the deposition of PW8. PW8 BDO Patrapur has stated that JE measures the work and later he checks measures the work. He has further stated that on 25/6/1994, much earlier.
Does PW8 says when he took over? Because your case is you have been transferred. And PW8 has been examined now.
My lord.
Whether does he say that when he took over, that 19 and 26 issue can be sorted out from?
No, my lord, but here he is saying that happened much earlier. That is what I'm saying. My lord, we kindly see the date. This is 25/6/1994. Yes, my lord. A year back. So, my lord, he has check measured the development work of Bodua Canal, which means the JE must have measured the same earlier to 25/6/1994.
Okay.
So, my lord, this entire thing is a very stale issue.
I understand.
PW9 village level worker Boratula and Tumba has stated that JE after completion of work has taken measurement of the work of the said tank. BDO had cross check measured the same. Accused JE also prepared the bill in respect of the work. So now, my lord, the village level worker is saying that everything is already done.
By that time.
Yes, my lord, by that time. That in light of the deposition of DW1, PW8 and 9, it is clear that the reason for which the accused person is alleged to have demanded bribe did not exist as he had completed all his responsibility in terms of the work.
By then there was no occasion for demand.
No occasion.
Yes.
I completely pardon.
Yes.
Now, my lord, on the question of exchange of MV, this is in regard to the second allegation made by his wife that I did not give. There is two allegations of asking for money. One is measuring it and preparing bill. I have already submitted. Now, second is I had the measurement book. I did not give it to her.
Right.
Now, my lord, to that, my reply is that the prosecution failed to prove if the money was paid in exchange of measurement book at the time of the trial.
Yes.
PW5, the complainant has stated that before taking the money, the accused JE showed him the NB book,
yes,
but did not part with the same. On receipt of the tainted GC note, the accused handed over the NB book to him. Whereas PW3, who had accompanied the complainant to the house of the accused in his deposition, has not whispered anything about exchange of MB book.
Yes.
PW10, the investigating officer in his chief, has stated that MV book number 3 of 1992-93 of Bodotola GP were seized. The cash record relating to the construction of Bodua Canal of Bodotola GP first and final bill for rupees this being signed by accused JE was seized on production by the accused. However, in cross-examination, PW10 gave a contradictory statement that he seized the MV book and other documents on production by the informant in the residence of the accused. The informant has not stated before me that after receipt of the bribe money, the accused handed over the measurement book to him. PW6, who in her cross-examination has stated MV book belongs to a panchayat. Well, this is also a relevant point. There is no record in our office to show that she had handed over the MV book to the accused. Now, my lord, here is relevant because every panchayat book, my lord, has a measurement book. It is supposed to be there in their custody. So there is no record in the panchayat records to show that she had ever given it to the accused.
Yes.
PW8, who was the then BDO Patrapur block, in his cross has stated that Exhibit 8 is the MV book of the Gram Panchayat, is to be kept in the custody of the Secretary of Gram Panchayat. So how that was given to me on the first place was never given.
Yes.
PW9, who has also stated in the examination that the GP is the custodian of the MV book. Further, DW1 in his chief examination has stated that as per office order number this, the accused had been transferred from Patrapur block to Chhatrapur block and he was relieved from Patrapur block on 11/9/1995.
That is the alibi plea.
Well, that is alibi.
D1.
Well,
yes.
From the above, it can safely be inferred that the Secretary of GP should have the custody of the MV book. If PW6 states that MV book was not in the office and she was requesting the accused to hand it over, then it is questionable as to why there was no objection or official complaint against the accused for illegally possessing the MV book. It is also relevant to state that the accused could not have had the MV book after handing over of charge. It is also worthwhile to
It's
mention.
all these things are regarding the discrepancy in so far as MB book is concerned.
Absolutely, I completely.
That I understand.
Madam.
Next, issue
Now,
4.
Now, my lord, discrepancy in receiving the tainted GC note.
Come. That is the important.
Madam.
Section 20 comes.
Madam.
There. See, all these things are improbability theory you are bringing. It's all right. But when it comes to 20, how will you get out of 20?
That I've got two legs to stand on that.
Yes.
One is I am also relying on the judge, the latest jurisprudence of the law, which says that if you cannot prove the demand itself, then mere recovery of money cannot stand by itself, in spite of Section 20. Well, that's my first ground. And second, even factually, if I can come to factually. As per the story of the prosecution, after receiving the tainted GC notes, upon apprehending the presence of the trap parties, the accused made Halla and his wife, Srimati Sanjukta Panda, came in and tried to get out the decoy and the accompanying witness. And further hearing the Halla, the front door neighbor, Sri Suresh Kumar Bari, came in and he made over the tainted bribe notes amounting to rupees Atiki by Srimati, and he went out of the shop for business. But it is interesting to note that the decoy complainant PW5 during his examination has stated that getting signal from accompanying witness, vigilance staff reached there. One of the vigilance staff who accompanied us immediately caught hold of the hand of the accused and gave his identity. In the meantime, the wife of the accused snatched away the tainted GC note from the possession of the accused and handed over to the neighbor Ramesh Gowda. In the meantime, the daughter of the accused disclosed that the tainted GC notes have been handed over to their neighbor Ramesh Gowda. Then Ramesh Gowda was called there and hand wash taken with that solution, due to which color of the solution changed to red.
Ramesh Gowda was examined.
Ramesh
Gowda was examined.
No, my humble submission is...
you could have examined him as a defense witness. Because your case is when the money was given to the accused, the wife of the accused has snatched away the money and gave it to Gowda. So therefore, you are creating doubt whether it was forcefully given or something of that sort. Who would have supported you? Gowda would have supported you.
No, but this is not my case. That's I completely bow down. If it would have been my case, your lordship would have said that why
they say Gowda.
It is their case. My lord may kindly see the decoy complainant PW5 only says this. This is not my case. My lord may kindly see para number 2 again.
Yes. I got it.
That is
the prosecution case.
Yes, madam. That is the prosecution case.
Whether the prosecution examined Gowda?
That is my case. That is exactly my case. My lord may kindly bear with me.
Yes.
Then Ramesh Gowda was called this. Thereafter, Ramesh Gowda admitted before us that the wife of accused had given him the tainted notes to him in the house. Thereafter, Ramesh Gowda produced. PW4 in his examination stated
Gowda would have been a better witness for the prosecution to establish the...
That is my humble submission. My lord may kindly see 4.
Yes.
I'll come to it, my lord. Now, para number
From
3.
the above version.
PW4 in his examination has stated that being asked to produce the tainted GC note, the wife of the accused disclosed before us to have handed over the same to an outsider. The outsider, who is the neighbor of the accused being asked, also admitted to have received the GC note from the wife of the accused. The tainted GC note was then recovered from the said outsider and handed over. Now, my lord, kindly see my ground here in para number 4. From the above versions of the witnesses, there arises a reasonable doubt as to from whom the said tainted GC notes were recovered. Whether from Suresh Chandra
Now three characters have come.
Suresh Chandra Bari, Ramesh Gowda, and
wife of the accused. Wife of
the accused.
Yes.
Now, my lord, may kindly see the next page.
Pre-trap procedures.
Pre-trap procedures.
That you said within 45 minutes, 2 hours, 45 minutes.
My lord.
Everything has happened.
My lord. And also, I have, my lord, that is why I said at 2 p.m. this has happened. 4 p.m. official.
4:45, everything is concluded.
4:45, the trap has been laid. I have also given, my lord, judgments. My lord, in the...
What is the distance between the vigilance office and your trapping place? Have you found out?
My lord,
just check it up.
My lord, I'll do so, my lord.
Because we are emphasizing on this 2 hours, 45 minutes.
My lord.
Then you just check it up. What are the nearby vicinity or...
I completely. I'll find out the distance, my lord. But here also it is that official witnesses arrived at 4 p.m. at Barampur Vigilance Office. Third paragraph, my lord.
You are relying upon Mahendra Mara, no?
My lord, I'm relying on Mahendra. Now, my lord,
they have to very meticulously follow the procedure and...
My lord, yes. Then is the procedural irregularity, my lord. the non-examination of Vijay Kumar Sahu, the accompanying official witness, non-examination of Arjun Nayak,
Arjun
who
Nayak.
is the contractor for whom apparently the complainant and the secretary came and asked for doing, non-examination of Sanjukta
Sanjukta Panda and,
the wife, and Suresh Kumar Barik.
They could not have bargained the risk of examining the wife of accused.
May not be, but Suresh Kumar Barik at least. The non-examination of Ramesh Gowda.
Very fatal. Why should they take risk of bringing your wife to the witness box?
But at least Suresh Kumar Barik and Ramesh Gowda.
Ramesh Gowda would have been. Next
Suresh
page,
Kumar Barik.
page 10, you have said
Yes,
that. Ramesh Gowda.
Yes, my lord. Further, decoy has stated the GC notes were handed over to one Ramesh Gowda and his hand wash was also taken and was tested positive. But
I tell you, in this situation, non-examination of particular witness by the prosecution may not be fatal. Because whatever examination they have done, on that basis, if the case is made out. Why should they keep on calling everybody?
I completely, my lord, as your lordship said,
that can't be a ground
whether
for
the case is made out. That's the only, my lord, our entire endeavor is to find out whether a case is made out.
Then long and short of the matter is, there is a demand. But there was no occasion for demanding. This is your case. But there is a demand. There is a demand. Because the witnesses have said there is a demand. But why for it is demanded, whether it is for bill or for measurement book, it can get. And everything has taken place in 1 hour 45 minutes. Complaint goes, witnesses are called, draft procedure taken place, they came and trapped.
Well, from the registration of complaint to the trap itself is 2 hours 45 minutes. As
acceptance part, there is a complete confusion. Accused, they say accused received it, wife pull it up and gave it to Gowda, and from whom it is recovered. That's one area that needs to be examined. And therefore, section 20, you want to get out of section 20, saying that if the acceptance is not proved, they have not. So where is the question of 20? Where is the question of 20? That's what it
when the recovery of tainted money itself is questionable, and the prosecution could not, beyond all reasonable doubt, prove recovery of tainted note.
That's right. Therefore, section 20 will not come. Absolutely. Had it been a case of clear acceptance,
I completely.
Then 20 could have been employed for the purpose of conviction. But the acceptance itself is not true. So therefore 20 will not come. That's what
third ground,
long and short of it.
Third ground is, in alternative to my argument, is even if we assume for a moment, for the purpose of our argument, that the tainted notes were recovered, even then the judgment, the latest jurisprudence which says that when the demand itself has been clouded, there is no demand as such. I was not there. There is no purpose. Why have I demanded? You are not saying whether it is.
And why say something I haven't said?
Whether it's for bill, whether it's for measurement book. Why did I have the measurement book?
And by that time you are transferred out.
I have transferred. Video has said that it has been done a year back. So there is no. You have not.
Insofar as demand is concerned, this is the doubt you have created. Insofar as the acceptance is concerned, the other doubt you have created. Phenoptil test is done for whom? You, your wife, or Gowda?
Chemical examination.
Phenoptil test.
They are saying in the what I have gone through the paperwork. It is my hand on which they have found. That is their. That is what they have said.
But you have to labor there. Yes. If it is your case, the wife pulled up the money and gave it to Gowda. Why have you not conducted phenoptil test insofar as Gowda is concerned and wife is concerned? If your case, you have to establish the case.
Yes.
The chain has to complete. That you have not done.
That chain will be completed, my lords. But recovery part, so far as recovery part is concerned, chemical examination is positive. That means he has come in contact with the.
No, that's all right.
Yes.
He has accepted.
But once there is a recovery.
No, he has created a hulla. Somebody came and trying to give the money.
My lords, that has to be taken qua the 313 statement, what defense plea, what he has taken.
No, that is that.
Those things are there. And secondly, so far the transfer part is concerned,
you have the full paperwork with you.
Yes, my lords. I will check it out, my lord, because
are you sure?
it will be better if I can have another one.
Yes, Mr. Mohanty.
Well,
Do you have full paper book with you?
my lord, I have got the full paper.
Kindly
Can
give
you
me
give a photocopy to him?
Yes.
I'll try and give it.
And
I'll keep it tomorrow. Ma'am.
I'll keep it at a part head and
Well,
retain in the list.
Completely.
Get ready 3:30 every day. I will take it up. Anytime
Well,
I can take it.
Well, I need some time to prepare. my lord. Somewhere in the first week of April, or she may fix a date, we can complete.
Yeah, you prepare, I will accommodate you, but let it be there in the list.
Yes, it will be there.
Huh.
Yes.
I got the whole idea.
And so
We
far,
can
my lord,
finish it up.
so far, submission is concerned regarding he was transferred or that MB book was present with him or not, that is immaterial in view of section 7(1)(d). Even if there is no work, my lords, the impression has been given that I would be doing that work. 7(1)(d), my lord, Sayyid Akhtar.
Now, what impression? Whether for the measurement book or the bill?
For both, my lords.
No, you can't say that. He is demanding money for a particular purpose.
My lords.
If you are not able to establish what is the purpose, what is the...
I am going further, my lords. Even if there is no work with the accused, still he will be coming under the
No,
ambit.
is it your case that there is no work? If you have put forth a particular case,
but this is what
against
he says,
accused,
my lords.
you have to establish that. You can't say that even if.
I will examine and
This is what is the case is.
my lords.
You are demanding for the purpose of X. That X has to be established by you.
Yes.
Today you can't say that even if X is not there, I can convict. That is not permissible.
I mean, in my humble submission, if your lordship may kindly have a look at section 7(1)(d), it is very clear on that.
No, 7(1)(d) is all right, but
Yes.
having
That's
put
not the
forth,
case under the
having put forth a particular specific case against
I will
the
examine
accused,
that part.
can you turn out and say that in general thing also we can do it? You can't do that.
Let I will examine that part.
Okay.
And I will structure my
Part
argument.
Mr. Satya Mohanty argued at length. Mr. Rijvi and submitted the written note of
Hand it over in
written
court.
note, written note of submission, and partly heard. Mr. Rijvi seeks time to address the court. This is the matter.
Well, this paper book maybe handed over copy.
Paper book. Mr. Mohanty undertakes to supply the paper book to Mr. Rijvi. Okay. And it will be retained in the list. I'll accommodate you. You keep on reading whenever you are comfortable.
And if your lordship may fix up one date in the first week of April, that will be better.
No, I'll not send it to first week because I'll forget it. That's the problem. Let it be there next week. I will accommodate you. Don't worry. I'll accommodate you. But please, if it is there, then the pressure would be there to prepare. Otherwise, I'll forget. Again, from the beginning, I'll read. 2, 3. These are very old matters. We'll finish it up.
Yes.
See what is that? Just see the assignment.
Yes.
In this assignment, today, I don't think I can pick up regular matters.
So still, my lord, in spite of such circumstances, your lordship has disposed of more than 100 appeals.
I'm trying to do at least some appeal. We can do it. So why not?
In fact, on merit, your lordship has disposed on 14, 15 appeals on merit, my lord. Your lordship has heard and
I tried. Let us try to do.
Yes, ma'am.
I know it is a pressure on you, but still you try.
Yes, I will.
Right. Yeah, okay. Yes. And the PWs which you have pointed out, PW 6, 5, 8, and 10, particularly. The part which you are reading, highlight and just be ready with that.
Of the paper book?
5 and 6. 5 and...
No, all those I'm relying on, I'll keep a copy and the judgments as well.
The highlight for yes. Next. Anybody is ready?
I was on my legs.
I think you both of you are you are making every judge busy.
No,
and
I was younger and much more fitter, so he
can run around.
Took his chance.
Yes. What is this matter?
The matter, my lords, which would completely revolve around your lordships, my lords, how your lordship used it.
You have prepare anything?
No, I have not prepared a note because I was waiting to address your lordship. And yeah, there is already some note on the, there is already a note of submission in the record.
Do you have? Give me.
I might improve on it.
Just let us get a grip of the matter. What is exactly the issue? You have a copy?
Yes, your lordship will find it.
Do you have a copy, extra copy? Please give it to me.
I take your lordship minutes to the FIR. That will give your lordship an idea about what the matter is, my lord.
Don't refer to paper. You tell me what is the case is about.
case is this. That I'm only, there were two schools which were, two schools where examination was held. After examination was held, papers were tabulated, and that was done at the level of the district inspector of schools, circle inspector of schools now. Now, I am the headmaster.
Of one of the schools.
One of the schools.
Yes.
Now, there was a summer vacation. Summer vacation, somebody else was in charge. And the case against me is that a cheat comes to me, a handwritten cheat comes to me. After the examination papers were evaluated and the evaluation, tabulation, register and everything, result sheets were sent to me, I used to keep it on the safe custody. Now this cheat is signed by the DI schools, district inspector schools, my superior authority.
That's slip.
Slip. Then you send me those result sheets. I want to verify. So that result sheet was carried by a clerk in my office.
To the DI school.
DI
Yes.
schools. DI schools at that level, manipulation was done. And then some failed students, 14 or 15 or 38, that used to know, 15 in number, they were passed. It comes back. It comes back. And I keep it.
Which standard?
7, standard 7. And then vigilant inquiry. The FIR does not speak of my involvement. The FIR is very clear and specific that the entire manipulation, forgery, whatever, however way your lordship, interpolation, however way your lordship wants to put it, then it will be tampering. I would put it in a very broad term, like tampering of the result have occurred at in the level of the school, the DI schools. Along with his staff, that is the specific pointer and specific allegation in the fact. Now, I have been, my lords, implicated.
Under the area 120B.
34.
34.
34. That since there is no direct allegation of my involvement, because I had, of course, taken a plea that I was not getting charged during the vacations. Now the trial court finds that no, the thing happened thereafter. I mean, when manipulation is happening, the court also lost sight of the fact. My submission to that would be that the court also might have lost. Court could not factor in that if there is a manipulation, it can be anticipated also. If you are manipulating the answer sheet, you can also anticipate it to or predate it or
So who all are the accused then? The DI school is an accused.
There's the DI of schools who actually issued the sheet.
He is an accused.
He is
Yes.
an accused. The clerks, the other clerks.
Do carried the file to DI and they are accused.
This office, the manipulation was done.
Hmm.
And then there's a handwriting expert examined that and confirmed that the cheat also carries the signature of the DI schools. The cheat calling for the also carried. So I am that since I was the custodian.
You were robbed in 34. 34 you have been robbed.
The entire allegation is I should have been more careful. Now I will manage.
Was there any departmental proceeding?
No, your lordship is on the pat on the partner. I was on that. If your lordship accepts the entire allegation, I am a very, very negligent employee. I am a very negligent, but I can't go to jail. I might not be fit to consider. Rightly, as your lordship, that was my first reaction after hearing the matters when I was briefed on the matter. My first reaction was that the issuance thrown out for being so casually.
What are the charges? 468, 471?
No, 467.
467. End?
Forgery.
Forgery end?
477.
13(1)(d). 13(2) read with 13(1)(d).
13(1)(d).
1.
How have they brought D?
34.
31D.
D is that I gave a benefit to somebody else. 1D.
That has been dropped.
That has been omitted also from the.
Yes.
Correct.
Then what is the material against you? 467.
Post 67, my lord, there is nothing excepting that I was negligent. I should have verified and I should have waited for a signed order of the DI before releasing. I am the custodian. Just that part.
How many of you are convicted now?
My lord, everybody, 4 persons were convicted. Out of 4, 3 are already dead, including the DI is dead. And DI schools that Barik, under whose signature that cheat came and went, he was dead during the trial also. During the trial also he expired. So I am the only accused surviving.
Oh. Let us see then. Let us come to the relevant part of the evidence.
The judgment, Marat, I'll just take your option how he has dealt with it, Marat.
Yes.
Paragraph?
Yes.
Paragraph 10.
10.
PW3 was the senior clerk of the office of the DIS school, Sumatro, to testify that the answer papers of standard 7 students of all the English schools under the DIS school, Jaipur, were sent to the DIS school, Sumatro, for valuation in the year 1994, and the result sheets were prepared in the office of the circuit inspector, Jaipur, Circuit School, Jaipur, after collection of the results from the DIS schools in triplicate. Column 13 of the said result sheets in that year were filled up by him, and no corrections were made in the office of the DIS school, Sumarkot, or by him. Some other assistant had filled up some other columns in his presence, and thereafter the result sheets in triplicate were sent to the CIS school Jaipur. Further, according to him, he was confronted with some interpolation found in the result sheet, which were subsequently interpolated, and his specimen handwritings were also taken. PW4 stated regarding the seizure of dispatch register of DI office Jaipur by the Vigilance Inspector by Exhibit 10, and stated regarding 3 entries there, entry number so of different days, by the exhibits 11, 12, and 13 respectively. PW5 stated regarding the seizure of result sheets of Inspector of Schools relating to 4 schools seized under seizure list 1 and 2. Further, according to him, the Inspector of Vigilance, why I'm reading, I'm casting a little wider net so that your lordship has a sweep of the sweep of the evidence.
Yes.
The Inspector of Inspector of Vigilance also seized the result sheets of the Municipality High School number 2. Well, this is my school, Chandanbada, Jaipur, and UGM Harijan School, the Harijan side, Jaipur, in his presence, and the result sheets of Kabisuria ME School, Muniguda, with 1 paper chip on production by the headmaster, Surendranath Naik, and the seizure.
From your school, how many students were passed?
15.
No, the total 15 or from your school 15?
No, my school 15.
Because there are 3-4 schools are involved. Total, how many students?
50.
Total 15.
Total 15 were, 15 was passed.
I understand there are, because 5-6 schools are there. Total number of students are 15 or from your school 15?
Our school 15.
Your school 15, okay.
In the present, and the result sheets of Kabisuria ME School Munigada with 1 paper chip in production by the headmaster Surendranath Naik, and the seizure list exhibit 18 and 19 was the paper chip. PW6 was the handwriting expert who compared the specimen handwriting by Gananath Joshi, A1 to A10 and B1 to B10, and M. Prasad Rao, C1 to C18, with the disputed letter Z1, disputed letter V1, and signature there under W1, and another disputed signature W2, and disputed figures and writings in exhibit 8, 9, and 7 marked exhibit X1, X51, Y1, Y52, and on careful examination found that the person who wrote A1 to A10 and B1 to B7 also wrote the disputed writing Z1 as per his opinion report by exhibit 22. So, as per the opinion by PW6 exhibit 19 and the signature thereof in the cheat belonging to Gananath Joshi, the then DI school, who without any official letter had asked for the result sheet of Kabisuria ME School. Again, according to the opinion of PW6, the person who writes C1 to C18 also wrote V1 as per opinion report exhibit 22. V1 marked by PW6 with a letter from the office of DI of schools bearing number 5473 dated 19/9/94 to Headmaster Municipality High School number 2, dating the two students bearing roll number 3219 and 3189 were promoted to class 7 under consideration. Exhibit 15, the same letter was marked by prosecution through PW5. So as per the opinion report by PW6, accused M. Prasad Rao in his own hand has written exhibit 15, thereby promoting two students in the roll numbers as stated above without the knowledge of the CR school.
Then from it, it indicates that insofar as your school is concerned, there are only two students.
That appears, only two students.
Two students. Why are you saying 15 then?
15.
Total must be 15.
Total is 15.
Your school concerned is only two.
Two students.
That's what PW5 says.
Madam.
Yes, let us go there. Again, according to PW6.
According to PW6, the person who wrote B1 to B7 did not write the red enclosed disputed signature appearing in exhibit 15 and 16 marked as W1 and W2, purported to have been sent from the office of DI of school, did not belong to the same DI, Gananath Joshi, and those signatures have been forged. So corollary inference would be that the contents of exhibit 15 were stated to have been written by accused M. Prasad Rao. He also forged the signature of DI. I'm sorry, man, that the cheat was also a forged signature.
No, but the finding is they accuse M. Rao, whoever it is M. Rao. He has manipulated. He has also forged. And 16 without the knowledge of DI. And abuse his
official position by putting the seal of the DI of school after forging the signature and thereby illegally issued letters from the office of DI of schools by letter number so and so dated 19/9/94 promoting two students, wide exhibit 15 and wide letter number 4624.
Who is this M. Prasad Rao?
M. Prasad Rao is a clerk there.
In your school?
Man, he carried the.
Just tell me who is, note it down. Who is M. Prasad Rao? If he is the clerk in your school.
Retired teacher.
And then the manipulation is done at his end.
At his end. M. Prasad Rao is the retired teacher. He is accused number 1.
Then he has manipulated. That is the finding.
That is
because his signature tallies with the manipulated. Yes.
Promoting two students, right? Exhibit 15 and letter number 4624 dated 16/8/94, thereby promoting 11 students bearing roll numbers to have promoted to class 8 class under his consideration. Again, PW6 found several corrections in the result sheets and interpolations in the marks as pointed out in X1 to X50. Again, according to PW6, in the result sheets, the original word fail has been scored through and pass has been written. Subsequently, as noticed in Y1 to Y52 marked by him, either the path was written subsequently to the right or word fail or the original word fail has been changed to pass by overwriting or has been written separately. So even though no definite opinion was made by PW6 as to who had made the correction of pass and fail or interpolated the marks in the result sheet, the gist of his evidence revealed that D then DI, Gananath Joshi had issued the cheat of the letter 19 to the headmaster Kabisudja any school for production of his result sheets, but the subsequent letter 15 and 16 signatures in exhibit 15 and 16 signatures therein and the disputed result sheets of the disputed two schools were found to have been manipulated, interpolated, and forged either by the assistant attached teacher M. Prasad Rao, who stated to have issued 15 and 16, declaring 13 unsuccessful candidates to have passed, and there are several manipulation and interpolations in marks of different students who were originally failed as per copy of the result sheet of CI schools and that of DIF school Jaipur, but subsequently shown to have passed as per the result sheet of two schools while exhibit 7 and 9, the custodian of which were Harrier Koram Sudha Patnaik and Srimati Pomila Gantay. I am Harrier Koram Sudha Patnaik.
So then the finding is the manipulation is done by M. Prasad Rao and the DIF school, and he was the custodian. So therefore 34.
Custodian of the
So 467, how will you bring 460? Categorically finding manipulation done by M. Prasad Rao and the DIF schools and manually custodian. How will you bring 34 in 460?
And there is no evidence, that even the judgment managers accept that there is no direct evidence against me. Says because you were, there was a dereliction of duty on your part.
The luckiest part is all of them have died.
No, I concede.
Otherwise, that M. Prasad Rao would have argued that I have not done anything. He has done anything.
I'm fit to continue as the headmaster also. I can't go to jail for it. It is not a criminal negligence. It's a
Go through it.
negligence.
I will go through it, man. I will go through.
Yes.
It's a
This is categorical finding. 460, 471, everything is made out against DIF schools. There is no doubt about it.
There is no meeting of minds, nothing.
There are twofold manipulation, it looks like. First fold manipulation is fail has been made pass.
Yes.
And there is interpolation in the mark.
Yes.
And both the things have been done either by
Assistant teacher.
and the language used is the court is also not sure whether DI has done or the Prasad Rao has done. Just see the language. It says that
Then
language is
false letter was issued, which became the platform for taking the result sheet.
force. Just see the language of Mr. Pali. Just read it. It says that the school were found to have been manipulated and interpolated and forced either by so and so or by DI.
Yes. Either by this or that.
On this basis, you can sustain 467, 471. You have to be certain that he has done it.
Yes.
The finding is either he has done, he is done, but in the same time, he is the custodian. The Promila Gantayat and the Patnaik, for whom he is appearing. There is nothing against them as such. The finding. Let us go ahead. Let us go ahead. Yes. Handwriting expert. And see, manipulation thing only on the basis of handwriting expert you have to decide. The other evidence you may not get. These are because it's scientific evidence. You can't ignore scientific evidence.
Yes.
Vis-a-vis the oral evidence.
Oral evidence.
If you don't get support from the scientific evidence, what will you do?
But the whole case rests upon the examination of the GQD, government examination.
GQ only, except GQ, nothing else.
No.
And the GQ's level of evidence is GQ.
That's the only.
Because see, once GQ comes, then the oral evidence goes.
Yes.
Vis-a-vis that only you have to examine. Let us see, let us concentrate, read further. Let us see.
The opinion by the handwriting expert can be relied upon when supported by other items of internal and external evidence. Yeah, so and so, 2003. It is not the law that the handwriting expert's opinion can never be acted upon unless substantially corroborated by other evidence. In case where the reasons for opinion are convincing and there is no reliable evidence showing any doubt, the uncorroborated testimony of the handwriting expert may be relied upon. Yeah, 1980.
Yes, that's right. Yes.
That's what fell from your work. So basing upon this, when the evidence of PW6 has not been shaken by way of cross-examination by any of the accused, particularly M. Prasad Rao, the same can be accepted and can be held to be reliable with reference to the opinions in
Exhibit 15 and
16. So M. Prasad Rao has been crucified virtually. Has been virtually crucified by the trial judge. PW7, the assistant teacher of Municipality High School number 2, stated in his evidence that accused Jadeswar Patnaik, who was working as a clerk in the DI schools Jaipur, and he requested the headmaster to give the result sheets of any school, examination 94, and the headmaster gave him the result sheet, and those were returned to the school with some correction. But in cross-examination, he clarified that he did not remember who handed over result sheets to Jadeshwar Patnaik. So it is
Then that means it has gone from the custody of headmaster to DI in between the manipulation.
Jadeshwar Patnaik comes with the cheat, says that the DI school, this is the letter, and he has asked for the result sheet, so headmaster hands over. So he takes it. Then the manipulation happens in the DI school.
Yes.
Comes back and puts it back. So there was no reason for the petitioner, appellant before the lawsuit to suspect that anything was. A superior officer is sending back. He might have made corrections or done whatever.
Yes.
I'm not the examiner. I'm not the invigilator. I'm not the evaluator. Nothing. The whole thing is being maintained there. I was merely somebody comes with a letter. Later on, it turns out that the letter is false. That letter purportedly saying that the DI of schools has asked for these results. My superior has asked for that result. The letter itself is false.
Is there any allegation, any evidence which has come regarding financial transaction, money benefit, nothing?
But no evidence, particularly.
So that is the reason there is no corresponding charge out.
Yes. There is no evidence of my knowledge about the whole thing. I'm merely here, disconnected from the event, save and excepting being connected to the first part of the offense of 34. That's some act, overt act, but without knowledge. The second indictment is not
Yes.
the direct judgment from the Supreme
You
Court.
can't bring 34 into. Yes.
Second indictment is not made out against me. Knowledge is not there. But that the learned trial judge literally forces and pulls the inference out of 140 and convicts me as 30. That is the
Only on 34 you have it. Obviously, because the kind of evidence you have not participated in 467.
Okay, 34 is the physical act. That's his intention of saying. Physical act means I physically took that result sheet and gave it. And knowledge because something happened there. That part is saying, even if it is that part is your knowledge is directly, there is no evidence, no whisper or anything of mine. There is a prior concert, as that Dani's case. Prior concert is not there, no meeting of minds, nothing. Yet, since you are negligent in your discharge of duties.
So therefore 34. Where is Mancheria then?
Therefore, 30.
I think it's very.
Is improbable.
And that is the regime is before NEP regime. Now the national education policy says that till 12th class pass everybody. Either you appear in the examination, don't appear. Those are the days 6th, 7th, and I think we people have appeared in that 6th, 7th board. And your generation might not have, but Mr. Palit might have appeared, and we are nearly same time. We appeared in those 6th, 7th used to be a board examination kind of.
Even in 7th class.
7th, yes, we appeared on those time. That was the regime. Now the education policy is like this. But see, the type of evidence is very, very weak.
Extremely far-fetched condition.
Very, very weak.
Extremely far.
Will you address tomorrow? Or I'll reserve, give written note and finish it up. What is this? Nothing.
Whatever that.
Prepare it if you have something.
Only notes matters.
Notes. All of them have died. Before he dies, let him die peacefully. Given
10 days to file the written notice.
10 days.
Lordship
Judgment, argument heard, judgment reserved. The parties are at liberty to file written note of submission within 10 days.
Lordship may kindly observe, Lordship heard me also.
Yes, of course. Mr. Palit, along with so-and-so for the appellate, and Mr. Rijvi for the vigilance. Parties are heard extensively and judgment reserved. Liberty granted to the parties to file written note of submission within 10 days.
10 days.
Within 10 days. Concentrate on 34.
Yes.
That knowledge part.
Yes.
Because the evidence we have read it out.
Yes.
And the only evidence is PW7.
Yes.
Only evidence PW7. There are three things you have to see. PW 6 or 7.
6, 7 and
6,
30,
7
and the contours of 30.
and exhibit 15 and 16.
Yes, ma'am.
And finding is Rao has done it and DI has done it.
Yes.
He has not done it. Under the aid of 34, he has been convicted. There is no knowledge. This is what is the long and short of this.
And that first will be on section 34.
34.
Yes.
Whether knowledge is there or not.
Yes.
Because it has come, very concrete evidence has come.
Yes.
Through GQ.
Yes.
That he has not manipulated.
Okay.
But whether he has knowledge of that or not, that is a question. You just see. Knowledge,
Yes.
I don't think knowledge.
Any no set of evidence, no restore any.
You also file a.
Can it be 14 days? Within 14 days. Lordship has granted 10 days within 14
Okay,
days.
14 days. No.
Wait.
14 days.
2 weeks. 2 weeks.
2 weeks.
Within
Yes.
2 weeks.
Yes.
Within 2 weeks.
With Lordship's kind permission, 101, where a young engineer has been dismissed on the ground of being convicted, and the other one is a retired person. There are 2 appeals. And he is cancer patient also. So today.
Tomorrow?
Yes.
See, I try to finish up my board by 3:30. After 3:30, whoever is there, I'll hear it.
We are there.
Today I was searching, nobody was there. Fortunately, Mr. Pandit came.
But
I am also here
in 100. At 2 p.m. I was lucky that I came in time because your Lordship stopped at 97. Had your Lordship proceeded, my 101 would have gone. There was a 2 p.m. matter fixed.
2 matters I could have here today.
2 p.m. for the Honorable Chief Justice, and
Yes.
that got over.
Then let it be there on the board both.
Tomorrow.
Tomorrow,
I have
include this.
I have been requesting one more thing.
Yes.
Mallet, I have all the documents with me. 1 or 2 exhibits are missing. Can I take it in pen
Yes,
drive?
of course, of course. You now, your junior, who is, you just take it up.
Ma'am.
Let him take the
So that I
pen
can
drive.
assist better in the matter.
Yes, yes.
Ma'am.
And whatever paper you have, please give it to Mr. Rijvi. Because see, he has to locate the paper.
See, LCR.
It's a matter of
deposition.
2020.
हाँ अच्छे अपन पके दे दियो तू so that easy
Well,
is
so
He's
far,
saying it's a matter of 23.
No, no,
Let me just clarify one thing. For 1.5 years, they
No, no,
never
no.
dismissed
I'm
me
not-
after my conviction.
I'm not on that, sir. Sir, just a minute. So 2023 matters is being dealt by Mr. Sanjay Kumar. So I will inform him.
No problem.
You have a
Only theory there will be lot of.
you have a dangerous opinion.
About to say that, let me not say it because it will be there will be a wrong information. But now that your Lordship has opted, I am very happy. I was thinking that he is there now, things have changed. I thought I will have a peaceful presentation of your Lordship. That will not happen. I am sure.
Mr. Das will be more peaceful than me.
My lord, well, I know now I am in trouble.
But we neither you have a choice nor I. So we'll hear tomorrow.
Resign to my friend. That's all.
Please tell him so that I'll retain it in the board. Prepare a note so that we can.
I will also may not be able to file tomorrow. Let me assist.
No, you assist me. Thereafter, you prepare a note. He, Mr. Palit also did the same thing. He relied upon a note, but he says that he will improve.
Okay.
Thank you very much. Great.